Mr. Zulu was rational, with or without res judicata. Now, we deal firstly with the rationality based on res judicata. We submit that the identification of His Majesty King Mr. Zulu took place on the 14th of May 2021. This identification, we submit, was the subject of full litigation before Justice Madondo in the KwaZulu-Natal Division, Pietermaritzburg. Judge Madondo found that the identification process complied with Zulu customary law. And that judgment of Madondo AJP was neither appealed against nor set aside. It's therefore, we submit, binding and final. And this judgment is to be found in Volume 1, pages 124 to page 167. We submit that the Court Accord correctly acknowledged this legal bar. And in this regard, we refer to the judgment in Volume 25, on page 4785, paragraph 31 and 32, on page 4787, paragraph 35, and page 4784, paragraph 36, page 4796, paragraph 61. Although the Court correctly acknowledged this legal bar, the Court inconsistently proceeded to grant relief that undermines the binding nature of that finding. And here we refer to Volume 25, page 4798, paragraph 2, 4794, paragraph 64. We therefore submit that the Court erred in reviewing the recognition decision, despite the recognition being premised on that same validated identification. We also submit that issue estoppel applies here. And for that submission, we rely on three authorities. The judgment of Smith versus Porritt, to which we have referred in our heads. Judgment of Caesar Stone, to which we have also referred, and the case of Royal AM Football Club. These authorities confirm that issue estoppel applies even where causes of action differ, provided the central issue is the same. And we submit that the central issue in both matters was and remains this: was King Mr. Zulu validly identified in accordance with Zulu custom? And we find this in Justice Madondo's judgment, Volume 1, page 43, paragraph 46, page 145, paragraph 51, page 146, paragraph 55, page 147, paragraph 58, page 149, paragraph 63, page 152, paragraph 75, page 153, paragraph 78, page 154, paragraph 80, page 159, paragraph 92, page 160, paragraph 93 and 94, page 161, paragraph 95, page 161, paragraph 96, page 162, paragraph 98, 163, paragraph 94, 163, paragraph 99, 164, paragraph 101, and we rely particularly on page 164, paragraph 101 for the issue relating to the application of Section 8, subsection 4 of the Traditional Act. And paragraph 165, page 165, paragraph 103. We submit that that issue has been finally decided and cannot be re-litigated because there was an appeal that lapsed because it was not prosecuted. We submit that that finding by the Court should have brought the matter to a close, and that the President cannot be compelled to re-litigate a factual issue which has already been judicially settled. We submit that to permit the issue to be reopened would undermine not only the President's constitutional function, but the authority of the courts. Once a High Court has confirmed the lawfulness of an identification process, it is subversive of the rule of law for a different branch of government or another court not sitting as a court of appeal to second-guess the same facts under the guise of a new review. Now, we deal now with independent rationality even without res judicata. Even if this court were to disregard res judicata, we submit that the record independently confirms that the identification process complied with Zulu custom and law and statutory procedure. The President had before him a coherent, evidence-based identification process, which includes, amongst others, minutes of the royal family meetings of the 14th of May and 29th September 2021, where King Msuzulu was identified in accordance with custom. And this is to be found in volume 2, pages 360 to page 364 of volume 2 of the record. That's the Zulu version.
I must warn you now, Mr. Morana, that 20 minutes of the minutes is up now. You may start experts, questioning members of
Yes, I appreciate that, Justice, yes. And page 365, still volume 2, 365 to 372 in the English version, and volume 6, pages 1116 to 1122, the English version. A resolution of the royal family meeting on 29th of September 2021, which reaffirmed the 14th May 2021 decision and clarified its consistency with custom. This is to be found in volume 4, page 735 to 736.
But what about the contention that those that were there in that meeting of the 14th of May were not members, family. Some key members of the royal family were not invited to the meeting. That's a convention.
Well, Justice Zondi, there are those allegations, but we.
Well, we know for a fact that Princess Taylor was invited.
She declined, yes.
And Prince Munisi was invited. About 3 people.
Yes. Not only that, Justice Zondi, but one of the litigants in this court, firstly, was aware of the meeting. That I'm referring to Prince Simagate. He wrote a letter and asked that that letter be read at that meeting. He knew that this was a meeting at which the successor to the deceased king was to be identified. He knew that. And he says that in the letter.
But Mr. Moran, there seem to be various interpretations of that letter.
Yes.
And they're there in the record. That's one of the problems. I think there are 2 or 3 interpretations of that letter in the record. One interpretation, he says, I'm not interested. The other interpretation, he says, but if I am nominated, I'm interested.
Yes, but the point I'm making, at this stage, Justice Nichols, is that he knew what the meeting was about.
Yes, certainly.
And the meeting was about choosing a successor to King Zwelithini. He knew that. There can be no doubt about that. He was invited to the meeting, but instead of attending the meeting, he decided to write a letter. And in that letter, he says, I'll paraphrase.
Let's go to, because I think it's a very critical document for the purposes of this case. Now, so well, it has been referred in various pages in the record. One can 745 where is the reference?
Yes, it's in volume 4, page 744. That is the original. The Zulu version is clear and legible. 744. Yes. Yes, it's exactly the same. Yes. Yes. In this letter, he effectively says. I kunjala stoliko. Yes, but unfortunately for those who are not conversant with the Zulu language, we'll have to toliga it. Yes. This is a very respectful letter. It's written in very respectful language. I mean, he greets the prince of Pindangeni, and he requests that the prince should read this statement publicly as it is written. As, in other words, he should read it as it's written. And then he says he hears that his name has been mentioned, that he, Smagade Jackson Zulu, wants the position of the king. He is very happy when he sees the prince on television saying himself that he, that is Prince Mr. Zulu, never said that he wants this position, and he confirms that. And he can also confirm that he has never said or told anybody that he wants this position. He hears that there are certain rumors, which indicate that there are probably certain people who wish that position for him, but there's nothing he can do about that. He wants to make clear that his aunt, the Princess Ndlovu, we know that is Tembi, together with the Prince Wasekwezi, they warned or advised us, being the children of the king, that if the monarch or the king or the great wife raises or mentions the name of any one of them, the one who has been so identified should accept. Therefore, if his name has been nominated, he would accept that nomination. And furthermore, they advised us or warned us that if any other one of us has been nominated, we should accept the position and support the one who would have been identified. As a child that is respectful and I think also humble, I emphasize that I would not go against the words of the old people, as I have mentioned above. I request or urge the Prince that when he reads the statement as it is, he should request the reporters that they should desist from keeping on phoning him about this matter, because there's nothing else that he can say apart from what he has already said. We thank you, Mageba. I'm your grandson, Prince Magade Zulu. So that's what the letter says. So it's quite clear.
But is he not sitting on the fence here to say, well, I'm going to wait an option? It seems to me that it's somebody who is, okay, I will behave, but if my name is,
Yes, that is so. That is so.
I'll go for it. So I'm ready.
That is so. But the point we are making is that he was aware what the purpose of the meeting was. And he was also aware of the outcome of that meeting, that in fact the person who had been chosen is at the time Prince Mr. Zulu. And in terms of his letter, he was expected to support that.
Mr. Morani, there's another interpretation of this letter on page 2826, which has slightly different nuances. Now, ngiyakwazi ukukhuluma isiZulu, kodwa angikwazi ukukhuluma. I don't know which one to follow.
Yeah, let's see. Justice Nichols, you say this was at page
2826.
2826. The court will bear with me. Volume 15. Yeah.
Look, like the other letter, it's somewhat ambiguous. It seems to state, I'm not going to go against my elders, but I think this one is more categoric in that if I'm nominated, I'll definitely accept.
Well,
But it is a different translation from the one that is available on 745.
Well, I tried my best, Justice Nichols, to interpret it as I was making my submissions. In any event, the points I'm making, I've already made the point that he was aware of the purpose of the meeting. So there can be no doubt about that. Although there are now attempts to sort of distance certain parties from the purpose of the meeting and the objectives of the meeting, and also what exactly happened at that meeting.
So your point is essentially that he was aware of the meeting.
Yes.
He knew that it was going to be to identify
Yes,
the king
yes,
or the potential king,
that is so.
and he chose to stay away.
That is so. Not only stay away, but also say that whoever is chosen, our elders have told us to support that person. But now, instead of supporting that person, he subsequently wants to be king himself. So that is a factor. And responding to one of Justice Nichols' questions, they actually don't say who should have been there and was not there. And our submission is that this was a lawfully constituted meeting, and people who should have been there were there, and the purpose of the meeting was legitimate, and that meeting came with a result which should have been supported by other members of the royal family. If I can just return to my argument. We submit that the attendance registers of both meetings demonstrated that the gatherings were broadly representative of the Zulu royal family. And there was a signed confirmation from Prince Buthelezi, and this appears in volume 3, pages...
Sorry, who called that meeting? Because, well, who called it? The person who called it, they have authority to do so.
Yes.
Who within the royal family, if meetings are to be held, who is responsible for calling the meeting? Because I'm not sure if there is a particular individual that can identify that if you are going to the meeting,
yes,
so and so is responsible for doing that, and we are not going to attend any meeting that is called by somebody else other than the person that we have identified.
Yes. Well, I know Princess Tembi at some stage, in declining to attend, said she was not going to attend meetings in kitchens or something to that effect. But our submission is that in time immemorial, meetings of the royal family were called by Prince Mangosuthu Buthelezi. And he was entitled to that. And that's another finding by Justice Matondo.
So he was calling that meeting in his capacity as the Prime Minister, the British Prime Minister, and in his capacity as the Prince, because he's part of the family.
Yes. And not only that, but there's a precedent. He had been calling such meetings in the past.
But he had been involved with the family for 6 decades.
That is correct. At volume 19, page 3792, the answering affidavit of Prince Buthelezi to Prince Mbonisi's application in the High Court. The heading is, I call meetings of Zulu Royal House. And paragraph 54, in terms of Zulu customs and traditions, the role of Prime Minister Undunankulu of the Zulu nation from time immemorial has always been to convene meetings of the royal family to discuss matters pertaining to the royal house, royal family, usually on the instruction of the reigning king. And in the absence of any such king, I'm entitled to call such meetings of my own accord as and when the need arises. During my tenure as Prime Minister, there has never been an instance in which a meeting of the royal family has been called by any person other than me, either doing so on my own accord or in the instruction of the reigning king.
Mr. Morani, Was there not some debate about this affidavit being struck out because it was unsigned? If you could just tell me exactly what the status of this affidavit is at present.
Well, it was not struck out. It's still very much evidence on which this court can make its findings.
Was it ever signed?
I beg you?
Was it ever signed?
Well,
It doesn't seem so.
well, in any event, it's in Justice Madondo's judgment. He confirms this fact.
It confirms what?
I beg your pardon?
I didn't hear you. I'm sorry.
I-
Justice Madondo's judgment, he confirms?
This very fact which appears that I've been reading, in other words, that Prince Mangosuthu Buthelezi was the Ndunankulu and he always called such meetings. Yes, we've got independent confirmation of that. Now, we submit that all these materials collectively satisfy the requirements of Section 8.1 of the Leadership Act, requiring identification by the royal family in accordance with custom. And also Section 8, subsection 3A of the Leadership Act, authorizing the President to act on such an identification. And we also submit that this is also consonant with the standard of rationality in the exercise of public power. We submit that on this independent basis, therefore, the President's recognition decision is legally unassailable. We further submit that it's worth stressing that the President's decision was not made hastily or on partial information. He had before him not only the record of the royal family's decision, but also the Premier's written confirmation that the royal family had met and reached consensus alongside dissenting views. The President also had before him a letter dated 5th of August 2021 from the Premier of KwaZulu-Natal, and this appears in Volume 3, page 578, 579, which confirmed that the royal family had met and nominated His Majesty King Misuzulu, and that there was a factional objection led by Princess Tembi and Prince Simagade. This letter was referred to in the Minister's letter to the President dated 16 March 2022, and this appears in Volume 13, page 2568 to 2572.
Would that letter, Mr. Mavani, constitute consultation as set out in the Act? It seems to me that Section 8 requires consultation with the Minister and the Premier. And it appears to me that there is a bit of a contention that there was no consultation with the Premier.
Well, we deal with this later, but our submission is that there was consultation. The mode or the modus of consultation is not prescribed, but once the President asked the Minister to confer with the Premier, that, in our submission, is his way of consulting.
Consulting with the Premier.
I beg your pardon?
Consulting with the Premier.
Yes. Yes. Now, So we submit that the President, therefore, had the benefit of the Premier's views, and consultation did occur. Here we're concerned with substance, not form. Yes.
Well, the President had asked the Minister to act in consultation with the provincial government.
That is correct. That is correct. Yes. Yes. Now, we say that the President balanced this material and acted rationally in the constitutional sense. Now, in relation to res judicata, Prince Magate contends that he was neither cited nor served or heard in the application brought by Prince Mbonisi before Justice Madondo.
I'm sorry to interrupt.
Yes.
Before you deal with res judicata issue, let's deal with the identification. Prince Magate, what? He said that he was identified at the meeting that was held on the 5th of May.
Yes.
You remember the meeting on the 5th of May?
Yes, that was, we believe, a rather...
Prince Mboni,
yes.
well, Prince Mboni is attended that meeting.
Yes.
The meeting of the 5th of May. But
Yeah.
Prince Mboni denies that Prince Smart was identified. What do you make of it?
Well, firstly, we submit that was a clandestine meeting. It was not a properly constituted meeting, and secondly, whether or not Prince Simagate was identified, there is a letter here dated the 11th of May. Yes. Prince Simagate sort of gives the lie to that version in the letter that he wrote. The letter of the 11th of May, that was read out, which he said should be read out. It will recall that it's a lie, that I want this position. It sort of gives a lie to what happened on the 5th of May.
So you're saying that on the 14th of May, his letter should have said, I've also been nominated.
Yes.
Okay. You may proceed with your res judicata.
As the court pleases. Then he, that's this Prince Smagate, says, no relief was sought against him and the judgment was handed down without his knowledge or participation. Therefore, any factual findings made in that judgment cannot bind him under the doctrine of res judicata or issues estoppel. He also argues that the High Court erred in finding that Justice Madondo's judgment precluded his claim because the requirements of res judicata, especially the requirement of the matter being between the same parties, was not met, and he frames the reliance on res judicata as a violation of his right to be heard and to have his claim considered on the merits. We submit that res judicata applies also through issue estoppel, even where the parties are different, provided the same factual or legal issue is being re-litigated. And for this submission, as I've indicated to the court, we rely on Smith versus Porritt, which provides that the test is whether the same issue was finally decided, not whether the parties are strictly the same.
On that score, can you go to McDonald AJP's judgment and see how he identified the issues? There were 3 cases before him.
Yes.
Is that so?
Yes. Which particular paragraph, Justice?
I just want to, you're right. You've already referred to his judgment at page 127 of the record. The first matter that he dealt with to address is Queen Sibongi in Fred. And then that is paragraph 128.
Paragraph 128. Paragraph 128.
Yes. Then he identifies the issue.
Paragraph 128.
Page 128.
Page 1, yes.
He started with the matter between Queen Sibongi in Fred Zulu and Queen Bushemata. This was Queen Bushemata.
Yes.
All right. Then he identifies the issues at page 135, paragraph 23, 135.
Yes.
So it would seem to me that it was not necessary for him to deal with the identification issue in order to arrive at a decision relating to the matter between Queen Sibongi Zulu and Queen Bushema. So he doesn't say the issue here is about it's whether Prince Misuzu was correctly identified. Let's go to, and then it deals with the second matter, page the second matter, the princess's application, Princess Zulu, is page 142. And then there, at 146, page 146, he identifies the issues. He says number B, paragraph 56, number B. He says whether the applicant princesses are entitled to stay in the process leading to the identification, nomination, recognition, coronation of Prince Misuzu. So he does identify the identification issue here.
Yes.
The identification as an issue for the purpose of determining
Yes.
the claims of the princesses here.
That is so. That is
Then
so.
let's go to the third case, which the third matter was before him. The third matter that was before him, it's a matter between Prince Mbonisi Bekikamba Zulu and Prince Misuzu.
Yes.
Okay, that's a third case.
That is so.
Then let's go to page 153, where he identifies the issues.
Yes.
Paragraph 78, he identifies the issues. Number C, he says the issues whether Prince Misuzu was legitimately and appropriately identified and nominated as the successor to the late Kisile.
Yes.
So at least in two of the matters that were before him,
Yes.
the issue of identification was squarely before him, and
Precisely.
he had to decide that issue in order to arrive at his conclusion.
Absolutely.
Okay.
Absolutely. Yes.
So, to that extent, one will argue that it was not necessary for a subsequent court to revisit the issue because
Yeah.
it's an issue that was addressed by Madondo AJP
Yes.
in two of the matters that were before him.
That is so. That is so.
But what about the fact that Prince Simagati says, well, I was not part of the proceedings in those matters?
Well, he might not have been part, but he signed a confirmatory affidavit.
I was looking for that confirmatory affidavit.
I beg your pardon.
Did he sign a confirmatory affidavit?
Yes.
Because that
Yeah.
is what Josh Davis said in his document, that he had signed, but there was no reference to the relevant thing.
We'll find the reference.
No thing that will help you. Okay.
Yes, yes, yes,
Proceed.
yes.
Mr. Moran, the difficulty I have with Judge Davis's judgment is at paragraph 36, he states, I therefore find that the plea of res judicata raised on behalf of the respondents is good and it's not open for this court to overturn the judgment
Yes,
of Madondo OJP.
yes,
But his order seems to indicate the exact opposite.
precisely. Precisely. That is a problem we have with the judgment, with the inconsistent treatment of the identification. Yes, yes. As a matter of fact, Justice Nichols, we say that is the Achilles heel of the judgment. With regard to the issue that was raised as to whether or not Prince Smagatis signed a conference, volume 20, page 3871. Yes. Yes. Yeah, he says, I'm a major male, and he gives his identity number, and I'm related to the late Zulu, His Majesty, and as such, I'm a beneficiary to his last will and testament, which is a subject matter in this application, and a member of the royal family. I've read the founding affidavit, etc., and I've seen the report of the handwriting expert, which concludes that the signature on the aforesaid will is not that. I fully support the relief sought in Part A of the Notice of Motion as amended. To that end, I consent to the orders break. So he did sign a confirmatory.
So what page are you reading from Moran?
I beg your pardon?
3871. Okay.
Yes. Yes, 3871. Yes. Well, we submit that Prince Magate had an interest and opportunity to intervene as he was aware of the dispute and the litigation, and as I say, he even signed a confirmatory affidavit. If he had a legitimate claim, he could and should have applied to intervene, And we further submit that Prince Simagati was indirectly represented, even if not formally cited. His interests were aligned with the anti-recognition faction led by Prince Mbonisi. The litigation raised the same core challenges now being pursued by Prince Simagati. And the finding on the lawfulness of the identification process, we submit, was central to the disposition of the interim relief. It's not merely academic. Well, regardless of whether Prince Simagati views the judgment as binding, the President was entitled to rely on the judgment as binding and in force. We refer in this regard to the matter of Koti versus the registrar, to the effect that decisions not under appeal or interdict are operative and they may be acted upon. It is also true that the Constitutional Court in Mulaudzi has recognized that the res judicata principle can be relaxed in circumstances where the relaxation of the principle may be done, in rare and exceptional circumstances where there is no alternative effective remedy. However, we submit that Simagati was not without a remedy. He hasn't told the court that the rescission did not apply. And if Prince Simagati believed that the judgment of Justice Madondo was handed down in error or without procedural fairness, he could have sought a rescission under Rule 42.1 or common law rescission principles. He did not pursue this route, and he cannot bypass that by launching a collateral review and ignore.
Could he have challenged that? Well, could he have been able to seek rescission under Rule 42 in view of the fact that he was not a part of the judgment?
Yes. I mean, if a judgment is arrived at in error, for instance, etc., and he's able to establish an interest, see no reason why he couldn't.
On the assumption that he had applied for intervention.
I beg your pardon?
On the assumption that he would have applied for intervention.
Yes.
From the court to intervene.
Yes, that was one of the things which he could have done.
Okay.
Yes. Now, the next heading is that the recognition decision was lawful. We submit that the President acted within the four corners of the law and in strict compliance with Section 8, subsection 3 of the Act. And that decision was informed by, firstly, the resolution of the royal family from its 14 May decision and 29 September meetings, and the authoritative judgment of Justice Madondo. And we submit that the President had no discretion under Section 8, subsection 4 of the Act, because no proper allegation, we submit, or dispute had been lodged. We submit that the section is not properly triggered. And we submit that the President, Justice Patwane, consulted with the Minister as required and recognized King Misuzulu only after the High Court had confirmed the validity of the identification. He thus acted consistently with both the law and custom.
But do you accept that Prince Simagati could not have brought a review of the President's decision until the President actually made a decision.
Yes. That is the President's decision. That is correct. That is correct. But if he wanted to upset Justice Madondo's decision, then he could have pursued a different route. Now, we submit that the...
Can you just go to, I think that you need to interrogate section 8.4 of the leadership, which imposes an obligation on the President that if there is evidence and allegation that the identification of the person as a king was not done in terms of the customary law and custom, then he must.
Yes.
Okay. We are not under section 59
No.
in the dispute.
No.
Where evidence
Yes.
must be used.
Yes.
But it's an allegation here. What kind of an allegation would be sufficient for the President, would be sufficient to enable the President to refer the issue for discussion?
Well, firstly, Justice Zondi, it has to be a bona fide allegation, and there has to be evidence. In other words, it shouldn't be a frivolous.
This came being Lovu's letter of the 3rd of June 2021, which addressed to the President, and
Yes.
she explained in great detail what had happened.
Yes. Yes. That is so, Justice Zondi. And Justice Madondo actually deals comprehensively, we submit, with that particular objection or complaint. And this is at paragraph 101 of the judgment. And we are also relying on a decided case,
Paragraph
101.
yes.
I think it bears an analysis, Justice.
Well, I see it's 11:05. 7 minutes past 11 now.
Yes.
Should we take an adjournment now until 25 past?
Yes. As a
Court
court,
will adjourn until 25 past 11.
as a court, please.
Yes, Mr. Morane, you referred us to paragraph 101 of
That,
882 Matondo's judgment.
that is so.
Yes.
That is so. Now, according to Justice Madondo in this paragraph, there's no genuine dispute as to the succession of Prince Misuzulu, as he is, in terms of the customary law and customs, the rightful heir to the throne. No one has disputed the correctness of the customary law and customs by which the name of Prince Misuzulu was raised and endorsed by the royal family. The applicant prince, neither in their founding affidavit nor in their supplementary and replying affidavits have made any assertion that the appointment of Prince Misuzulu was not in accordance with Zulu customary law and traditions. The letter that Princess Thembi Ndlovu addressed to the President, stating that there was a disagreement in the Zulu royal family as to who should succeed to the throne between Prince Misuzulu and Prince Simagade, did not comply with the provisions of Section 8, subsection 4 of the Leadership Act. The President should act when there is evidence or an allegation that the identification of a person as a king or queen was not done in accordance with customary law and customs. No such evidence or allegation has been brought to the notice of the President in this regard. The letter of Princess Thembi Ndlovu lacked the necessary allegation that Prince Misuzulu, who was identified by the royal family, had not been identified in accordance with Zulu customary law and traditions, and that Prince Simagade has a better right or entitlement to succeed to the throne. More so, it is common cause that Prince Simagade declined the nomination. As a result, he is not a contender. Even if he purported to accept the nomination, he could not have legitimately been identified, as he does not qualify in terms of Zulu customary law and customs. Prince Simagade's purported identification was accordingly doomed. The applicant has therefore failed to make out a case that there is a dispute about the successor to the throne on the basis of which the President or the Premier may investigate or refer the matter back to the Zulu royal family for consideration and resolution. And this is what the President relied upon. Now,
but, well, the statement that there is no genuine dispute as to the succession, is that what is required in terms of Section 8.4? Because 8.4 refers to an evidence allegation. So we agree that we are not in the realm of Section 59.
Yes.
We are at Section 8.4, allegation.
yes.
And my question to you was, what Princess Thembi raised in her letter that she addressed to the President in June 2021?
Yes.
Is it sufficient to form a basis for the conclusion that there is an allegation that the identification was not done in accordance with customary law and custom? That's my question to you.
Yes, we submit not. And Justice Zondi, we are actually relying on the judgment of Justice Madondo with regard to that. And we are also relying on a decision of the Constitutional Court. It's the case of Chief Abetendi Rachibumo Rambuda and others. This is Chivumo Royal Family and Others versus Chivumo Royal Family and Others at 2024 ZACC 15, which held that the Premier in that matter has to satisfy himself that the evidence or an allegation of non-compliance with customary law in the identification of the person before was not frivolously advanced, before referring the dispute to the relevant bodies in terms of the Limpopo Traditional Leadership Act, which we submit echoes the act with which we are dealing here.
But that act doesn't, the wording of that act doesn't say he made, the Premier made, as opposed to must. I think that it does make a huge difference, the use of must and may. But with respect, Justice Zondi, it doesn't alter the principle that it should not be a frivolous allegation. It should be a bona fide allegation, and it should also refer to the identification in terms of customary law. To that extent, we submit that case is authority in this case also. So let me see if I understand your submission tomorrow. Your submission is that Princess Kenby's letter in which she catalogued a number of irregularities. Those allegations were frivolous, to use a language. I'm not sure. If my understanding of your submission is correct.
Well, we say that they were not directed at the question as to whether the identification was in terms of custom and customary law. That's the critical and crucial aspect of it. I mean, a person can conjure up a dispute based on the fact that the person identified as king to be does not fit the bill in terms of let's say morality or some other factor which is not aligned to customary law. That is the real crucial issue. Yes.
But isn't one of the crucial issues is whether it should be King Zulu because he's the firstborn son of the late king, or whether this Ufagwe Siswen because he's the firstborn son out of wedlock, so to say.
Well, Justice Collins, it will be recalled that that issue of Ufagwa Esiswini was abandoned.
Has it been abandoned?
Yes.
Well, I think that Mr. Moran is still a live issue because he relied on two experts, Professor Zulu and the Tamba
Mapalala.
Well, there's Professor Zulu who does say something about this custom of Ufaka Esiswini and Zimande. These are the authorities upon which he relies for the contention that as a person was inserted, he is entitled to succeed to the throne.
In my recollection, Justice Ronnie and Justice Nichols, I do not believe that Princess Tembi's letter dealt with that particular issue.
I can refer you to page 2487, the custom of ufagesisweni.
Volume 13.
2487.
At the bottom of the page of 2487, where the heading is Custom of ufagesisweni.
Yes, well, I can put it no higher than that. The President was relying on the judgment of Justice Madondo on this issue relating to 8-4. Yeah, and that is paragraph 98 in particular. Yes, paragraph 97 and 98 of Justice Madondo's judgment. Yes. In terms of paragraph 97, the learned judge says, Priest Mangosud Telias, who was in attendance at the meeting, states that before proposing and nominating the name of Prince Misuzulu as a successor to the late Isilo, he explained the criteria which are to be taken into account when identifying a person as successor to the throne. Such criteria are laid down by Zulu customary law and customs. The following criteria are taken into account: whether the ilobolo of that person's mother was contributed wholly or in part by the relevant tribe or nation, and the status of the maternal grandfather of such person. In the present case, it's common cause that the late Queen's ilobolo was paid by the Zulu nation, and that she was born of Eswatini royalty, being a daughter of King Sobhuza II. On the ground of the contribution of her ilobolo by the Zulu nation alone, she precedes other wives in polygamous marriages and becomes a great wife who is expected to bear successor to the throne. The status of her father may now legitimately be interpreted as constituting discrimination on a listed ground, that is birth, and could be in conflict with the equality clause. If it discriminates unfairly against other wives born of commoners, it may fall foul of the provisions of the clause. But the fact that her ilobolo was provided by the Zulu nation cannot be assailed, and it's not a listed ground, but a fact which only serves as a distinguishing feature. It's common cause that there is no contender to the Zulu royal throne. Prince Magade, who has been mooted as a possible contender, addressed a letter to Prince Mangosuthu dated the 11th May with a request that the letter should be read out at the Zulu royal family meeting on the 14th of May. In that letter, he disavowed claim to the throne or any intention to claim it. He indicated that he was willing to abide by the decision of the royal family. As a consequence, Prince Misuzulu remains the undisputed successor to the Zulu throne. The two princesses confessedly stated that their application has nothing to do with succession to the throne. It's been argued that Prince Misuzulu has been appointed as successor to the late Isilo by late Queen, who had been nominated and appointed as successor. However, the will of the late Queen is not impeached. The inevitable conclusion is that even if the late Isilo's will is found to be invalid, it would not have any bearing on the succession to the Zulu throne. In addition, the Zulu royal family, which in terms of the Leadership Act and customary law has the prerogative to appoint traditional leadership, assembled on the 14th of May and identified Prince Misuzulu as a successor to the late Isilo. And as I've indicated, I beg your pardon, we are relying on the finding by Justice Madondo, which has not been upset, it's not been taken on review, it's not been appealed against. Now, as far as the remedy is concerned, we submit that remittal was legally inappropriate. We submit that the High Court erred in remitting the matter for an investigation process under Section 8, subsection 4, when it had already held that the identification itself could not be revisited. This is internally inconsistent and contrary to principles of finality in litigation. That contradiction in the High Court's reasoning is stark. It accepted that the identification could not be revisited due to res judicata, but then remitted the matter for further investigation steps to assess the very same identification. I think Justice Nichols raised that issue. That is an internal incoherence that undermines finality, certainty, and the logic of administrative remedies. There was thus no basis to order the remittal, as that was the end of the inquiry, as the list between the parties is no longer alive. Then we refer to the case of Fusion Properties. This is Stellenbosch Municipality, 2010 Zaska 74. This court emphasized that remedies must be tied to a legal entitlement, not a grievance. And in Mulauz versus S, 2015 ZACC, Constitutional Court warned against exceptionalism in overriding res judicata without clear injustice. None arises here, we submit. There is nothing in this record to signal that rare and exceptional circumstances exist, and that there is no alternative effective remedy to justify the relaxation of the res judicata principle. The case has been heard, decided, and relied upon, and finality must prevail. Then we also refer to the case of the Ngwenyama Minerals, 2011, Volume 4, SA 113, Constitutional Court. There the court stressed that remedy must be just and equitable in light of the facts. A remittal based on a non-existent dispute is neither just nor equitable. This is not a case that turns on factual ambiguity. The facts are known, tested in court, and acted upon. President exercises judgment in the face of contestation, not confusion. And to second guess his decision now is to invite uncertainty into a space that requires finality. The remittal relief sought by Prince Magade under 81C1 of PAJA, requiring the President to initiate fresh procedures, is tantamount to judicial supervision over a discretionary executive function. The Constitutional Court has consistently held that such remedies are to be used sparingly and only in cases of manifest injustice, and we submit that this is not such a case. Now, our conclusion, we respectfully submit that the recognition decision of the President was lawful, rational, and in full compliance with the Act, that there was no duty to initiate an investigation under Section 8, subsection 4, and the High Court's order setting aside the recognition decision we submit should be reversed, and we ask that the appeal be upheld, and that the recognition decision be reinstated, that the review application dismissed with cost, including the cost of 3 counsel. May it please the court, those are submissions.
Cost of 3 counsel.
3 counsel. Yes. Those are submissions.
Well, that case, as far as the cost liability issue is concerned, we did not be guided by award principle. You are PMPL of the government minister.
Yes.
And the president. So.
Yes. we would submit, Justice Zondi, that not in this case.
Yes.
Here we are dealing basically with contestants who be king. Prince Mbonisi, on the other hand, says that the king should be Prince Buzabazi. Yes, and we submit that this contestation for kingship should not really be brought to the level of the principle of biowatch. Those are submissions as far as costs are concerned.
There's just one aspect that I just want you to address us on. It would seem to me, on reading Madonna AJP's judgment, let's go to paragraph 91. He did not exclude the possibility of attacking the identification once a recognition decision has been taken. Just look at what he says in paragraph 91 and as well as in paragraph 102 of his judgment. One might say he indicated that the door was still open to whoever wishes to challenge the identification, but that could only be done once the recognition decision has been made. I'm not sure if my understanding of those relevant paragraphs are correct.
Yes, Justice Zondi.
Yes.
He does say that, but it does not detract from all the submissions that we have made regarding the finality of his judgment relating to the identification issue.
Right.
Yes. After the identification, of course, anybody can challenge the recognition decision on legally recognizable grounds. But in this case, we say there are none.
Okay. Thank you very much.
That's a copy.
Yes, Mr. Ngoy.
Thank you.
The platform is yours. Your 10 minutes will begin once you are ready. Your 20 minutes.
No, Justice Tony, I don't like to disagree with the judge at the commencement. It's 20 minutes. Deputy President and Honorable Justices of the Court.
5 to 12 now.
Yes, 5 to 12. Thank you. Thank you, Deputy President. The key findings of the court below are in volume 25 at page 4794. And that's the first key finding at paragraph 56. And that is where the judge refers to section 8.4 and specifically says that that section means that the mere making of an assertion that traditional laws and customs have not been followed is sufficient. The next key finding is at paragraph 60, which is at 4795, the same volume, where he says that the President erred in law in purporting to perform an evaluative function. And that is why he then says that the recognition decision is acceptable to review. And then the last key finding is at 4796, paragraph 61, where at the end of that paragraph he says, it terms thereof, it is notionally possible that should the investigative committee have regard to material which had not been placed before Madondo AJP within the strictures of the application that had served before him, it may either reach a different conclusion or may determine a re-election as a more appropriate course. Such a course, should it be advised, would render any adjudication of the meeting of 14 May 2021 moot. So it's on those reasons that the order, which is at paragraph 66, order number 2, 4798, says that the matter is remitted so that an investigative committee can consider whether or not the identification of my client, His Majesty King Mrs. Zulu, was not done in terms of customary law and customs. Now, what is the problem with that? We submit that there are 5 problems why that finding is incompetent. The first is that the court failed to correctly interpret section 8.4a. The second is that the court failed to properly analyze the evidence. The third is that the judgment, especially the order at paragraph 66.2, contains a glaring internal contradiction. Justice Nichols has already pointed out to the contradiction with paragraph 36, because paragraph 66 undoes paragraph 36. Now, a judge who gives an order that is internally contradictory, the order itself is irrational, it cannot be upheld on appeal. The fourth is that the judge failed to uphold and apply customary law when it was applicable. He actually did a secutus or a secular ruling. And the fifth is that the judge failed to apply the principle of issue estoppel, because he allowed both the issue of identification and recognition to be relitigated before him when it had been finally litigated before Judge Madondo. If I may then start with the first issue, which is the correct interpretation of section 8.4a. We don't have a problem with the judge's articulation of the principles of interpretation, which focus on text, context, and purpose. There he was correct. But we submit that where he went wrong was on the application of those principles. The text, just to remind the court of the relevant section, which is section 8.4a. that text says the following, 848. Where there is evidence or an allegation that the identification of a person as a king or queen, and then it goes on, was not done in terms of customary law and customs, the president, as the case may be, must cause an investigation. Now, we have no difficulty with the second part, that the president is obliged to cause an investigation. The problem is the first part. What is the yardstick to trigger the investigation? So we say the first relevant indicator is that Section 84A is concerned with customary law. Customary law has its source in the Constitution, particularly at Section 211, subsection 1, subsection 2, and subsection 3. Section 211, subsection 1, is the crucial section because it says that the institution, status, and role of traditional leadership, and then it says, according to customary law, are recognized subject to the Constitution. So the traditional leadership institution is an institution that must function according to customary law. What that section illustrates, therefore, is that it is the customary law that is the fulcrum or the prism through which traditional leadership exists, and there is an obligation on our courts, you will find that in Section 211, subsection 3, to apply customary law where it is applicable. That informs then the nature of the allegation that is referred to in Section 84 sub A, which would then trigger the obligation on the president to cause an investigation. And that is an allegation that the identification of the king was not done in accordance with customary law. The first baseline of how to look at Section 84A has already been decided in the Chivumo case that my learned colleague has referred to, which is that as a baseline, the allegation must not be frivolous. But we say that's not enough. In addition to guarding against frivolity, the allegation must be reasonable and bona fide. And the allegation must identify the custom on which it is relied in order to come to the conclusion that it was not complied with. That structure, firstly, of ensuring that there is no frivolity, secondly, of ensuring that the custom is identified and the practice that did not comply with the custom is also identified, ensures two outcomes. Firstly, it prevents abuse, but also secondly, it gives effect to the centrality of customary law to the structure of traditional leadership. And so what this means is that, contrary to the finding of Davis J., it is not the mere assertion that is required by the Act, but it is an assertion that illustrates the nature of the custom and the respects in which it was not fulfilled. But also it is an allegation that is bona fide and reasonably made. And that would therefore require any court interpreting Section 84A to first identify the content of the custom. The custom is X. And secondly, to set out why it is alleged that the nomination or the identification has not been done in accordance with that custom. We then can look at what happened here, which takes me to my second issue, which is whether or not the court was correct in its evaluation of the evidence that the president had before him allegations that King Zulu was not identified in accordance with customary law. When you look at the judgment itself, it's actually extremely difficult, the judgment of Davis J. It's extremely difficult to work out which document is he relying upon to come to the conclusion that there was an allegation before the president that customary law was not followed? So, because the analysis of the judge, this is in volume 25. So when you look at the analysis of the judge, it starts at 4787, and there is a heading, the recognition decision. He sets out the facts, but where he has to address the question whether or not there was an allegation that custom was not followed, you will find that at paragraph 56, page 4794. Paragraph 57, 58, 59, 60, 61. Thereafter, he asserts a conclusion. So we are left none the wiser about what is the allegation that he is relying upon. We then have to go back and say, well, maybe he is talking about his narration of the facts, but nowhere does he ever identify the allegation that was before the president, and then assess that allegation by reference to the statute. So the best then we can do is going back to the judgment and trying to figure this out at page 4787, paragraph 39, where there is a reference to the letter of the 3rd of June, 2021. And at page 4788, the judgment says, the president further considered in his affidavit that Princess Thembi had contended that King Mrs. Zulu cannot be recognized, appointed, and be coronated in terms of the constitution, customary law, and both the national and provincial legislation. That you'll find at 4788. And then paragraph 40, in his answering affidavit, the president also indicated that according to the premier, it became clear during the process of nominations the royal family was divided on the final decision as to who should be the successor. And then you then, at paragraph 42, there's a reference to the letter of the 9th of March, 2022. That's the letter that comes from Prince Mbonisi's attorneys, Mabaso attorneys. So it seems, therefore, if we are to take a generous view of the judgment, that there are two documents that are said to constitute the evidentiary basis for Section 84A. Unfortunately, the second document, which is the letter from Mabaso attorneys, did not exist at the time of the judgment by Judge Madondo. But the letter from Princess Thembi has been dealt with by Judge Madondo at paragraph 101. And he is clear that that letter does not meet the threshold for a complaint that customary law was not followed in the identification of King Mrs. Zulu. That letter itself is at volume 13, page 2468. So the first answer to the question whether there was an allegation is that it has been dealt with finally by Judge Madondo. But if we look at the letter itself at volume 13, page 2468, so the actual letter signed by the princess doesn't say anything. The letter is 2468 to 2469. It's the attachment that refers to this alleged allegation. But the problem with that letter is that it's actually very difficult to pinpoint an allegation that says that King Mrs. Zulu was not identified in accordance with custom. Nowhere does it specify the process that must be followed under Zulu customary law for the identification of a king. And nowhere does it say the following steps were not fulfilled in the context of the identification of King Mrs. Zulu as a king of the Zulu. The first time, after there's quite a lot of things that are being said in the letter, the complaint about the will, and the complaint about whether or not the late King Zwelithini, was correct in identifying Queen Mantombi as regent. But the question that must be answered by Section 8.4a is whether the identification of the reigning monarch of the Zulu, King Misuzulu, was not done in accordance with customary law. The first references we get there is at page 2508 and 2509. But we need to look closely at what is being said. At page 2508, paragraph 10.16, this is what is being said. In a bid to salvage his case, Prince Buthelezi called a meeting scheduled for the 14th of May, purportedly at the behest of the matriarch of the royal family. In terms of the court papers reported on at page 5 of Isolezwe, dated 23 May 2021, Prince Buthelezi is reported to have said, on the 14th of May, the royal family met and unanimously decided that Prince Misuzulu ascend to the throne as the king of the Zulu nation. It is vehemently disputed that this meeting could have salvaged Prince Buthelezi's case, given the fact that this meeting was called under false pretense and it was intended for the ironing out of differences between Prince Buthelezi and Prince Mbonisi and Princess Thembi on the other. And then it goes on about the false pretense. Then it says, but instead throws Prince Mbonisi and Princess Thembi into the deep end by drafting them into the agenda to acknowledge the nomination and ascendance of Prince Misuzulu without their knowledge and consent. Then it talks about the agenda. And then further, it is appropriate to record that princes and princesses born of His Majesty were invited to the meeting under false pretenses. So far, there is no identification of the custom of the Zulu on the succession of the king, and there is no identification of the manner in which that custom was not complied with. Then we look at page 2509. We also get a conclusory statement at paragraph 10.17. Having regard to the aforegoing, it follows that at no stage was Prince Misuzulu identified and or nominated and accepted by the royal family for the purposes of being recognized and appointed as the one to ascend to the throne for the following reasons. They talk about the 7th of May meeting, the 14th of May meeting, and then they say it is vehemently averred that having regard to the preceding paragraphs, Prince Misuzulu cannot be recognized, appointed, and coronated in terms of the Constitution, customary law, and both the national and provincial legislatures. It is vehemently averred that the decision to identify the king rests with the family in terms of the Constitution, customary law, and both the national and provincial legislations. So this is the full extent of what you will get the references to custom. There is no allegation that the identification of King Misuzulu was not done in accordance with customary law. In fact, there is not even an attempt to set out the content of customary law. The president had this letter. He says he had it. In fact, the president addresses this issue at volume 6. And again, it's important to look closely at what he says. At volume 6, page 1020. So at volume 6, 1020, the president responds to this. He never says that this letter constituted an allegation that the identification of King Misuzulu was not done in accordance with customary law. He says in the middle of the paragraph, the upshot of this letter is that it notes that Prince Misuzulu was never identified and or nominated and accepted by the royal family for purposes of being recognized and appointed as the one to ascend to the throne. Now we have to draw a distinction between the role of the royal family, which is a statutory role, and the custom of identifying a king, which is a pure customary practice. The two seem to have been conflated. The insertion of the royal family into the identification is a statutory requirement, which we accept must be fulfilled. But it is not a customary requirement. The custom is clear. It's set out in various paragraphs.
All right, I must warn you that 20 minutes.
Yes, this is, it came at the right time. Yes, it came at the right time.
Under protection.
Yes, yes, thank you, Justice Stone. So, just to close this part, there is a distinction between the statutory requirement that the royal family must be involved. That is all contained in the Poison Act. But the succession in this case is in accordance with custom. What is the custom? The custom is set out in various paragraphs, but most importantly, it is contained in the affidavit of Prince Buthelezi. Now, I am not talking about the unsigned affidavit. I'm talking about the signed affidavit, which was filed in opposition to the interim interdict. That you will find at volume 10. At volume 10, page so the affidavit starts at page 1095. But he then sets out what the custom is. And you will find there the custom is set out at page 1932 and 1933. So he says, before Judge Madondo, I explained what the custom is. And the custom is set out at page 1933. It says, the heir to the throne was thus a matter settled or predetermined by Zulu custom and customary law. It is settled custom that a queen born of royalty takes precedence over any other queen or wife of the king, in this case the late king. It is also settled customary law that the queen of royalty for whom the nation paid lobola is a bearer of the king to ascend to the throne after the death of the reigning king. Paragraph 52. The Zulu nation paid lobola for the late queen, that's Queen Mandom. In terms of the Zulu custom, the payment of lobola by the nation to secure the betrothal of the late queen and the late king served as a guarantee or surety to the Zulu nation that the first son born out of that relationship would be the successor to the throne. Now, I accept that there are Section 9 problems that arise here, but they are irrelevant for this case. This is a case of 3 men. Paragraph 53, the implications of the Zulu nation paying lobola for the bride are far-reaching. It creates an inextricable social pact between the two nations that the first son born of the marriage between the two royals will produce a successor to the throne. The late queen's status as a daughter of another royal family, the king of Eswatini, she was the daughter of King Sobus, was itself a predeterminant that she should bear a successor by Zulu custom, elevated her above all other wives, present and future. The custom is prevalent among and is adhered to by most, if not all, the Nguni nations. It is also embraced by most, if not all, Africans, indigenous nations, and universal recognition for this custom among the Nguni people. Now, this custom has actually never been disputed in this case. Even the allegation about ukufakwa proceeds on the assumption that this is the correct custom. It is an issue of seniority within the custom that is accepted. But even if it was disputed, we were the respondents in the court below. And on Plascon Evans, our version of the custom, supported by Prince Buthelezi, who has been around since 1968, for 50 years, would have been accepted as the correct rendition of custom. Now, of course, it is true that there was this meeting of the 5th of May, but it is dealt with in this affidavit fully. At page 1936, paragraph 115, it is a secret meeting, but it is also irrelevant in terms of the custom. But it is also contradictory, because the one says so-and-so was identified, but the other says they were not identified. But it's dealt with on the papers. What is also dealt with is the question of the composition of the royal family.
Okay. Your first problem in that meeting is that it was secret, and the second one is, I think, it's
Well, there is contradiction about what was discussed.
what was discussed.
Yes, about specifically about the identification, there's contradiction. Yes. But it has no status in customary law, as Prince Buthelezi points out. But it also deals with the question about the composition of the royal family. That you will find at 1923, from paragraph 71, right up to paragraph 88. Now, that's the respondent's version about who comprises the royal family. It also deals with the status of Prince Mangosuthu Buthelezi as a Prime Minister of the Zulu nation, and therefore entitled to convene meetings, including meetings about succession. So we come back then to where we were. These three questions, the propriety of the meeting of the 14th of May, are dealt with fully in the answering affidavit. The nature of the customary law is dealt with fully. The meeting of the 5th of May, 2021 is also dealt with fully in the answering affidavit. We then come back to the President's decision to recognize. Under Section 84A, the President had to recognize unless he had an allegation that the identification was not done in accordance with custom. I've taken the court now through to the actual document. That document says many things, but what you will never find in it is an identification of the custom and the manner in which King Misuzulu's nomination contradicted that custom. Especially since we now know that custom pre-exists the royal family. The royal family is a recent invention by statute. But custom pre-existed. And that is why Prince Buthelezi says there was nothing that the royal family could do if the custom had been complied with. Of course, the candidate needed not to be disqualified under Section 8. The candidate is disqualified, mentally incapable, or any of those disqualification criteria. Then they would not be qualified.
Well, let's go back to that meeting of the 14th of May. The person who called that meeting, President Buthelezi,
Yes.
was authorized to do so. He did have authority to do so. Because that's one of the allegations on which they rely for the contention that that meeting was improperly constituted.
Yes, but even if we...
Sorry. My next question is, do we have an established practice in terms of which the meetings are called within the royal family? Do we have someone who has been identified to say, Prince so-and-so is responsible for calling the meeting which has not been called by Prince so-and-so, we are not going to attend so.
Yes. The affidavit of... but let me try and answer this question. To trigger a Section 84A response by the President, it's a narrow inquiry. It is whether the identification was not in accordance with customary law. That's got nothing to do with the composition of the royal family. It's got nothing to do with the calling of the meeting of the royal family. Those are all statutory requirements. The question in custom, if, for instance, they had taken the second-born son and said, well, this is the person.
Well. But that would be the last step of the process. One would imagine that it would be a first step that would culminate in the identification. It doesn't take place in vacuum. Something must be done before
Yes.
the platform is created for it.
But that does not trigger Section 84A, because Section 84A is a specific provision, which is the actual identification that it seeks to impugn. And it seeks to impugn it on a very narrow ground, that it was not done in accordance with custom. So you always have to establish what is the rule of custom that you claim was breached. If you cannot say that in your allegation, and that is why Judge Madondo's paragraph 101 is actually unassailable, because he says it fails to contain the necessary averments that would comply with Section 841, because they can't identify the custom, and therefore they can't identify the breach of that custom. But if we are to broaden the debate into the question of that meeting, who has the right to call the meeting? We know that from the affidavit of Prince Buthelezi himself, he says he has called these meetings for more than 50 years, since he became the Prime Minister of the Zulu nation. That you will see at so where he first addresses 1914 of volume 10, from paragraph 49, that's where he first addresses the attacks on him personally. And then thereafter, he explains at paragraph 55, where the whole thing started of him being involved in the affairs of the kingdom. Paragraph 55.1, in September 1968, when my cousin, King Cyprian Beguzulu Kasolomon, passed away, I made all of the arrangements for his funeral. I had served him for 14 years as a Prime Minister of the Zulu monarch and nation, a position he had appointment into in 1954 during the unveiling of King Shaka's tombstone. In all my years of service to the king, not a word was uttered by anyone suggesting that I was using my position for any kind of gain. There is no payment to this position, and it carries with it a burden of responsibility that few would be willing to bear. Then he goes on to talk about, this seems to be his complaints about the ANC. But they're not particularly relevant. Then at 1923, from 71, I've already referred to that. And then 73, at page 1923, for the reasons I will explain in a moment, I'm an expert in Zulu custom and customary laws. I have acquired this expertise through information and history, passed on to me by my forebears in accordance with Zulu oral traditions. 75, he explains his knowledge. 78, that he himself was born of royalty. And then 81, where he talks about his mother, Princess Magogo. And then the composition of the royal family, 84. And then the meetings of the royal family from 89, that he convened those. He was entitled to convene those in terms of his position as the Prime Minister. 93, 94, 95, 96, he attaches the minutes. 100, paragraph 100, and then up to 104. So we submit, therefore, it's clear on the papers that were before the High Court. The person with the authority to call these meetings is Prince Buthelezi. He derives that authority in part now from customs since 1954. He knows who comprises the royal family from his own personal experience. And then that is why he's then entitled from paragraph 105 onwards to say this is how the king was identified. My colleague is pointing me to paragraph 82, so maybe I should have read it out. Paragraph 82, I referred to the paragraph, I didn't read it out. I think that's what is being said. Paragraph 82, 1925, my role as the Prime Minister, Undunangulu, of the Zulu nation, from time immemorial, has always been to convene meetings of the royal family, to discuss matters pertaining to the royal house, royal family, usually on the instruction of the reigning king. And in the absence of any such king, I'm entitled to call such meetings of my own accord as and when the need arises. During my tenure as Prime Minister, there has never been an instance in which a meeting of the royal family has been called by any person other than me, either doing so of my own accord or on the instructions of the reigning king. So if we are to expand the debate and ask whether or not Prince Buthelezi had the locus standi as Prime Minister to convene these meetings, the affidavit is clear and it's backed out by evidence.
The letter that was written by Prince Samakadi,
Yes, well, he didn't.
that was read out at the meeting.
Yes,
He was aware the meeting was taking place and it was about identification.
yes,
He never objected in that letter.
yes. No, he didn't. And there, Justice Salduka, it doesn't really matter whether you read his letter as saying, I am disavowing my claim, or whether you read his letter saying, I'm reserving my position in case I get nominated. The fact of the matter is that he knew that there was a meeting about identification. And it's clear from the agenda that this is a meeting
Now,
about identification.
There were two people who sent apologies,
Yes,
and that was him and Princess Tembi.
Princess Tembi, yes.
But is there anything in the papers that indicates that they were both objecting to a meeting taking place then about the identification application? In terms of the customary?
No. Well, this is the whole thing about this custom that when we move from the royal family, into the custom, the content of the custom is clear. The person who must succeed is a person born of royal blood, whose mother, because Justice Madondo actually captures this very powerfully, he says succession follows the status of the mother.
And there's never been a dispute about that amongst the parties?
Never.
Now, if you look at Judge Davis's judgment with regard to this point, surely he would have had to deal with the identification as to whether or not it had occurred according to customary.
Yes.
To make the remittal.
Yes.
Because you can't make the remittal on the basis that you're going to have to appoint an investigative committee in terms of Section A4. Yes. Again, with regard to identification.
Yes, this is the problem. This is the third of my...
We're going round in circles.
Yes, this is exactly the problem. That's the third of my arguments, that the judgment contains an internal contradiction. Because at paragraph 36, he finds that the issue of identification is a closed matter. At paragraph 66, he says they must go back and do an identification again. So it's an irrational judgment.
Mr. Nkatabi, correct me if I'm wrong, but the impression I get is that your argument is quite a narrow one, is that Section 8.4, the only trigger to Section 8.4 is if there is been no proper identification, and there is nowhere in the papers anywhere that it is specifically alleged that King Zulu was not properly identified.
In accordance with custom. There are allegations.
In accordance with custom.
There are allegations about the royal family.
Yes. But in accordance with custom. Is that the sort of crux of your argument?
Yes. On the first part, that's the argument that, and that argument, Justice Nichols, you are correct about it. It comes from Judge Madondo, paragraph 101, that if you look at Princess Tembi's complaint, it says many things.
But it doesn't query the identification of King Zulu.
Yes. Nowhere does it.
According to custom.
According to custom, yes. This is a very simple exercise. You identify the custom, and then you identify the gap. What you cannot do, and this is the problem with Judge Davis's judgment, he says, as long as you mention custom in your letter, then you trigger Section 8.4. But that just makes nonsense of the statute.
And you say that the statute is quite narrow.
It's a narrow statute, yes. You have to identify the custom, and you have to identify the gap with that custom, the inconsistency, or the breach of the custom. You don't have to prove it, which is the evidence part, but at least you have to identify it, which is the allegation part.
So if the matter is remitted, I'm just thinking out aloud. If the matter is remitted and the investigative committee is appointed and they have to investigate the identification, so you have to go through contenders.
Yes.
And the contender has to be in terms of settled custom.
Yes. No,
born
precisely.
of royalty,
Yes, I mean, this is, well, I mean, there's a rule of law problem. You first have to set aside Judge Madondo's judgment in order to do what is in paragraph 66, because he is unequivocal that the identification is in accordance with customary law.
But you know, I understood your heads of argument to be saying res judicata is not viewing it through the lens of the Constitution, which surprised me somewhat because I thought res judicata would be in support of your client.
Yes, it is in support of my client. I'm not sure which part of my heads, but certainly in the second part of the heads, we firmly rely on in support of the recognition decision on res judicata.
Oh, I see.
Yes. And in support of the identification decision, we say that was done in accordance with custom. Yes. And we say that before the president, there was no allegation that it was not done in accordance with custom. In fact, we rely both on res judicata and issue estoppel. And issue estoppel covers both Prince Mbonisi and Princess Makade. They were there. They were in that court, either as applicants or as respondents, but they were there. Then the third topic, I've now covered the second topic, which is the analysis. There is a second letter, I've almost forgot about it. There is a second letter, which is the letter of the attorneys of Prince Mbonisi. That you will find
That was the one that was after the judgment.
That was after the judgment. So you'll find that in volume 1. From Mabaso attorneys, yes. Now, those are the only two letters referred to in the judgment, that were sent to the president. So that you will find at volume 1, at page 93, yes. Now, it's 3 pages, 4 pages. Its nub is to complain about section 8.1. That is the nub of that letter. And it never identifies the custom. It complains about the composition of the meeting of the 14th of May. But it never says this is the custom and this is why the custom was not followed. And then it then threatens litigation, threatens an appeal against Judge Madondo, and then it threatens a review of the president's recognition if the recognition goes through. But the problem is this, you still don't get to the threshold where the custom is identified and the gap is identified. And this is the problem everywhere you go. The issue was always, this meeting of the 14th of May was not properly composed. That was always the issue. But what they missed throughout was they were never able to say, in terms of the customary law of succession to kingship, these are the rules. And you did not meet those rules. So even that second letter simply falls below the threshold. And the logic of Judge Madondo in paragraph 101 equally applies to that letter from the attorneys. So that then takes me to the third point, which is that there is a glaring contradiction in the judgment, and already a lot of water has flown on this topic. You will find this contradiction at volume 25. So we start with paragraph 36, which is at page 4787. Because he says here, I therefore find that the plea of res judicata raised on behalf of the respondents is good and it is not open for this court to overturn the judgment of Madondo AJP. And then this is what he says, Justice Nichols, which is what would happen if the principal relief, namely the review and the setting aside of the identification decision of 14 May 2021, were to be ordered. So if I order this, I would therefore reopen Judge Madondo's decision. You compare that with what he actually ordered, which is at page 4798, paragraph 2. The matter of the recognition of the ISILO is remitted to the first respondent, who is directed to act in accordance with Section 8.4 and 8.5 of the Khoisan Act, to appoint an investigative committee as contemplated in that act, and then it says to conduct an investigation and to provide a report in respect of the allegations that the identification of the second respondent was not done in accordance with customary law and customs. The problem is that he has already closed the question of the identification, but he is also reopening it. So we would therefore submit that given this glaring contradiction, the judgment simply cannot stand. You have to scratch out the second part of the judgment so that it's a judgment that is internally consistent, beginning and end.
But in any event, the outcome of this investigative committee, can it undo Madondo AJ's judgment? Because that, it seems to be what the judge is suggesting at the end of paragraph 61.
Yes. Well, I mean, yes. Well, Justice Zondi,
Jurisprudentially, it can't happen.
yes. In law, it can't, but the judge thinks that it can. And because he says here, it is notionally possible that should the investigative committee have regard to material which had not been placed before Madondo AJP within the structures of the application that had served before him, it may either reach a different conclusion. So he then runs headway into the rule of law. Because now you have bureaucrats overturning judges. And so insofar then as there may still be an issue around this, my colleague, Mr. Morane, has referred the court to paragraph 101 of the judgment of Madondo, AJP, which closed the issue of identification. So we say that the third point is actually straightforward. You simply have to compare the judgment for internal consistency. And it's consequential here. It's not a mere happenstance. It's a consequential thing because the order that he gave is precluded by the finding he makes at paragraph 36. That then takes me to the fourth issue, and that's the issue whether or not there is still a question mark, because the basis of the paragraph 66.2 is that there is still a question mark about the identification of His Majesty King Mr. Zulu in accordance with customary law. That is something that needs to be investigated. But we say, firstly, on what was before the president, there was no allegation that the identification was not in accordance with customary law. I've already made submissions on that issue. But we also say on what was before the judge, there could be no real contest about customary law. This I have addressed already in relation to Prince Mangosuthu Buthelez's affidavit about the content of customary law. But it is also set out in volume 1, page 147. That's in the judgment of Judge Madondo. So if you see what he says about custom, in the middle of paragraph 59, it is the customary law, not common law, which should be strictly applied in resolving a traditional leadership dispute. The king is not appointed, but is determined by birth. Only a mother of a would-be king is appointed to bear an heir. The status of the mother or the person who intends to ascend to the throne or is to be appointed king is a decisive factor. So follow the status of the mother. Now, of course, we know here that what happened is that after the death of the late King Zwelithini, he nominated Queen Mantombi, and Queen Mantombi then nominated the eldest son. But that's not the issue before us. The issue is what is the custom in relation to the actual succession. So here he says the first rule is you follow the status of the mother. And then we also know that that is also supported by Prince Buthelezi. I've already referred to volume 10, page 1896, and up to page 1933. And the rules are clear. A woman of royal blood takes precedence, number one. Number two, a queen of royalty whose lobola is paid by the nation bears the heir. Number three, the Zulu nation paid lobola for Queen Mantombi. Number four, the late king nominated Queen Mantombi as regent. Number five, Queen Mantombi nominated King Misuzulu by custom. This is also supported by King Misuzulu's own affidavit. You will find that at volume 21, page 4183. So at page 4183, volume 21. Now this is the affidavit of my client, King Misuzulu, at paragraph 11.1. So firstly, he denies that Prince Makade is the so-called firstborn son of the late king, or that he was at any time considered to be a descendant in the sense of a blood relation, and thus born into the royal family of a son born from a wife of the king, which is also a queen. But then he sets out what the custom is, 11.2, 11.3, 11.4, 11.5, 11.6. Now, regrettably, he had to attach an unsigned affidavit of Prince Buthelezi for reasons that are known. But it was legally irrelevant because Prince Buthelezi had deposed to an affidavit in this matter before his passing on the same terms that are confirmed by King Misuzulu. And the unsigned affidavit, to the extent that the court wishes to have regard to it, but is largely confirmatory. You'll find that at volume 20, page 3837, the relevant paragraphs. So you'll find that at paragraph 197, 3837, volume 20, where he says, well, no one else was eligible under customary law because this is the custom 198, 199, 200, 201, 202, 203, 204. Then it goes on and on.
Now, the status of a person who has been affiliated to the great house through the custom of Father Association. When it comes to issue of succession, can that person overtake, as it were, the biological firstborn? I'm not sure.
Well, according to...
That's a basis upon which Prince Simagate is claiming to be entitled to be identified because the custom
was performed.
And that custom, in a way, elevated his status
Well, there are two answers to that, Deputy President. The first is that the basis for that allegation is Prince Zebulon's book. The authority for it is the book by Prince Zebulon. In other words, setting out what the custom is in relation to ukufakwa and what it does. Now, that is dealt with in the answering affidavit, the unsigned answering affidavit. But this is not important because it's an extract from the book itself. That you will find at 3852. And that is referring specifically to Prince Simakade. And there is a Zulu version at the beginning of the page. Okweta ukuba uSimakade abelelwe esigodlweni kwakhangela amankengane ukuthi ingane eyangithanda isencane lena ndaba ezitha. Ikwala noma kunemimoya eshisayo. Lena yenta ukuthi angahlali lo mntana lapha kimi. Bahlale bemlanda bethi hayi akufanele ahlale kimi. Kuyasa sethu umntana useyaqhamuka ngebhasi. Kanti usemncane kakhulu ukuba angazihambela yedwa. Ngagcina ngathi mina ngonyaka utakuhlahleka lo mntana ngoba lokhu ethatha ehanjiswa akayekele umntana ahlale lapho athanda khona. Uma engasathandi lapha kwakhangela amankengane uyakuphinda ahambe futhi nakhona. Imithi yonke nje yenkosi. Yena lo mntana ongowenkosi nje angahlala noma kuphi. Wathanda ke lo mntana kwangangoba nesikhoke nesikole wate wasiqeda ehlala nami lapha esigodlweni kwakhangela. The English translation comes immediately after that. What makes him Prince Simakade close to the Kwakhangela Mankengane Palace is that he was very close to me from his childhood, even though there was a bad vibe and a feeling that he was not supposed to stay with me. They would fetch him, and the following day we would see him getting off the bus. Even when he was too young to travel alone, I ended up suggesting to the king, that's a reference to Gonyama, that this child should be left alone to stay where he prefers to stay. Otherwise, he was going to wander away and get lost. If he prefers to go away from Kwakhangela, he will be free to leave because the king has many homesteads. So Prince Simakade lived with me at Kwakhangela until he finished school. So the first basis of this allegation of ukufakwa is not supported by the very authority that they refer to. But it is also refuted at the following page, 3853, paragraph 252, right up to 275. And one can imagine this, justices. Ukufakwa, especially at the royal family context, particularly ukufakwa for purpose of succession to kingship, is a big thing. There is not a shred of evidence, no photo, no picture, nothing of what transpired on the occasion. It's not a one-day event, it's a series of events to signify this elevation. So you have an empty assertion that is not backed up by any evidence. And then you have all of this evidence in the answering affidavit that authoritatively refutes it, because it's a big thing, it's a ceremony, it's an event, it's an occasion. And you find here...
Yeah, sorry. If now the allegation that he was inside, that he was forward, is correct. Well, you probably see.
Justice Zulu, can you just argue in Xhosa or Zulu? I have to make it easy for all of us, rather than going into the language and
We have to try because I mean it's customary law. We have everything is not going to be custom.
everything is language, right?
Assuming that this assertion is correct. Now, if that custom was correctly performed and it had legal consequences as suggested by Prince Simagate, then I found it strange that the Queen, that is late Mantombi,
Yes.
would have in her will nominated Prince Zulu, because I mean, if the custom of Ukufagwa has consequences that the person who has been inserted can overtake the biological heir, then one would have expected Queen Mantombi to have nominated him in her will.
Well, Justice Zulu, we would have expected the king himself.
Well, the king, maybe he didn't want to create a dispute within the family. He just maybe he wanted to stabilize the situation to say, I'm appointing my wife as a regent for the time being. Then it's for my wife to decide going forward. But I think that the whole purpose there was stability in the family.
Yes. Well, we agree incidentally with that. What is clear that the wish of King Zwelithini was that Queen Mantombi must make the decision.
Yes.
But if it is correct that Princess Magate got into the royal family through the custom of Ukufagwa, the purpose for Ukufagwa and his rendition was so that he could be the first in the line of succession. But that is a ceremony and a custom that would have been performed by the late king. So when the late king identifies the successor, the logic, according to Prince Magate, would have been, I have already decided the successor. I did the custom of Ukufagwa. And that is why I'm nominating Princess Magate. So the fact that the king never did so, the king decided that the decision ought to be made by Queen Mantombi is itself in conflict with any notion that Ukufagwa was performed for the purpose of determining succession. But in addition to that, Queen Mantombi would have been part and parcel of the custom of Ukufagwa. And she herself would have then nominated the person who has been adopted through the custom of Ukufagwa. But none of those things happened. And that's all in addition to the total lack of facts that are alleged by Prince Simagate. And the fact that the book that they rely upon explains what Prince Zebulon did. He went around interviewing the members of the royal family and interviewed the person directly, Queen Mantombi. How did this child get to this family? And Queen Mantombi explains what happened. And there's no reference there to the custom of Ukufagwa.
So are you saying that there was no, are you saying that there was no Ukufagwa customary rights that took place?
Yes, that is, if you go to page 3, firstly, on what is stated by Queen Mantombi, there was no such a custom. But at page 3853, that is expressly refuted. In fact, it says the custom of Ukufagwa was never performed.
Would Prince Simagate not have mentioned it in the letter if it was so important?
Well, yes, this is the point made eloquently by Mr. Morane, that if his claim to the to the kingship was that it was through the adoption by virtue of Ukufagwa, it would have been uppermost in his claim when he wrote the letter of the 11th of May. But Justice Zondi, at paragraph 259, page 3855, the question you asked me a minute ago, and I realized I didn't answer it. The answer is there. It is unheard of in all circumstances of a child affiliated to a house ever taking precedence over and above the children born of, in this case, the late queen and the late king during the subsistence of their marriage relationship.
But this being the unsigned affidavit
This is the unsigned.
of Prince Buthelezi, to what What weight was we attached to it?
It is supported by Zulu as a rendition of custom. And this is all much to do about nothing. There is an affidavit by Prince Buteles filed in answer to the interim interdict, which he signed.
But does he deal with Ugufagwa in that affidavit?
No, he doesn't. He doesn't deal with the custom of Ugufagwa. But there's a shorter answer to all of this, that the basis of that allegation is Prince Zebulon's book. Prince Zebulon's book contains a full extract of what Queen Mantombe stated. So we therefore submit that the custom of Ugufagwa is simply not a basis for a claim, a legitimate basis for a claim to succession. In fact, Judge Madondo was clear on this, that there are no other contenders. He had gone through the whole list. He came to the conclusion that there are no other contenders. I have already addressed the issue of the composition of the meeting of the royal family. The Mpepu decision, as correctly identified by Judge Madondo, is distinguishable, and that is where what they did, they took members of the royal council and conflated them with the members of the royal family, which then contaminated the meeting of the royal family. But here, the composition of the royal family is set out in the affidavit by Prince Buteles, the signed affidavit in response to the interim interdict proceedings.
Well, approximately 140 people were in attendance.
Yes.
But, well, there were some that were there for other purposes who were not really family members.
Yes.
And as opposed, well, then there's a meeting of the 5th of May. It was attended by how many people? 14 or
15.
15.
The affidavit says 15. Well, I mean, and then there is also, Justice Son, I'm glad you've raised that point, there is also the meeting of the 29th of September, you know, which is also attended quite significantly by the royal family. And there they debate, what should we do now in the light of all of these issues and the complaints? They are still unanimous, even at that meeting. They were unanimous on the 14th of May, they are unanimous on the 29th of September 2021.
Well, I see it's 1 o'clock now. It could be time to take a lunch.
Indeed.
Do you have some further submissions to make, or can I allow you to proceed? Or
no, I only have
want
one.
to cut you short?
I think I'm probably left with 20 minutes of my allocated.
then we'll come back.
I only have one item. I'll use the remaining time for that.
Okay. We'll come back at 2 o'clock. The court adjourned for lunch until 2 o'clock. Thank you.
Yes. Yes, I think on my allocated time, I've maximum 20 minutes. Yes. Thank you, Deputy President. Firstly, I want to, I think the answer I gave to Justice Nichols around the unsigned affidavit of Prince Buteles, I said in response that the court should not be worried because there is a signed affidavit submitted in the interim interdict application. She then said to me, well, it didn't deal with Ugufagwa. The actual record does, in fact, address fully the allegations of Ugufagwa. At volume 24, there is firstly an affidavit of Mr. Mdleche at page 4667, who is an expert in Zulu customary law. And in fact, that affidavit is exclusively addressing the allegations of Ugufagwa. So you will see that at 4669, paragraph 6 up to 11, and then from 4671, from paragraph 12, she then addresses the specific allegations made by Prince Makade and shows why those allegations do not meet the threshold for the custom of ukufakwa. And then she then deals with the factual position, which is what Prince Buthelezi also dealt with, which is this is a big event, this custom of ukufakwa. None of them within the Zulu royal household were aware of this, which is under the topic Our Collective Recollection from paragraph 13 to 17. And then he says at paragraph 17, two of us, Mr. Dlamini and Mr. Zenda, served as what can be described as abelusi, that is, overseers of the affairs relating to royal animals. In these capacities, we would have known of or been involved whenever cattle had to be dispensed, especially for the kind of cultural rituals such as ukufakwa esiswini. And then he then deals specifically, but there seems to be two types of ukufakwa. There is ordinary ukufakwa for mere mortals like me, and then there is ukufakwa in the royal household, for the elevated ones. And that's at paragraph 18 up to paragraph 20, where he describes the custom of ukufakwa in the royal households and says that there is actually no such no such event that took place. And the fact that Prince Makade was associated with the royal household at Kwakhangela Mankengan does not ipso facto mean that he was placed in the womb of the late queen, nor does it mean that he became entitled to become the successor to the late king, or rather that he gained a preferential entitlement to the throne as heir. And then Justice Sondi, he deals also at paragraph 20 with the point about the sequencing of the children. There were other children, he says, who were not the biological children of the late queen, who lived in or were associated with the royal household of the great wife, Queen Mandongo. Examples include Prince Sibusiso Sezwe Zulu, that resided or was associated with the royal household in question, did not mean that he had been placed in the womb of Queen Mandongo. That Prince Makade regarded the Indlunkulu household as home does not disclose that he was placed into the womb of the queen. And then they deal with this issue of the birthday gift, which again is another basis for the claim to succession from paragraph 21. They address that all the way to paragraph 24. And so ultimately it's clear there on what Mr. Mdleche, and you recall who Mr. Mdleche is, when Prince Buthelezi did a draft affidavit, he said, I've relied for the contents of the custom on Mr. Mdleche, as well as, I think it was Mr. Mapala, who was the second one. And so that's the affidavit of Mr. Mdleche, signed, admissible, answering affidavit. Plascon Evans makes that clear. And then you have another affidavit from an expert historian at page 4689 and 4690 of Mr. Mapalala. He addresses both the custom of ukufakwa and the process of identification of a king. So at 4698, he addresses the identification of King Misuzulu as to whether or not it followed custom. And what is apparent, of course, if you look at the origin of the Zulu kingdom, I mean, from Shaka, etc., yes, Shaka was not succeeded by the elder son from the great wife, but it's really a tracing of the custom from Mbande, which is at paragraph 38.1, that the affidavit really deals with Mbande, Cetshwayo, Dinuzulu, and then Solomon Bekuzulu, and then Zwelithini, 38.1 to 38.6. And then he addresses at 4701 the custom of ukufakwa esiswini, and again, which he says there is no such event that took place, and the conditions for ukufakwa esiswini were simply never met. So it is, the court can ignore entirely the affidavit of Prince Buthelezi on both questions, this question of the identification and the question of ukufakwa. What the court cannot ignore is Prince Buthelez's affidavits filed in the interim interdict application, King Mrs. Zulu's affidavit, Mr. Mdleche and Mr. Mapalala's affidavit, all of whom are speaking from experience but also from expertise. And we know here from all of the cases we've cited about the approach of the court towards customary law that the preference is towards historical expertise. And so you've got 4 here. This is an answering affidavit. Plascon Evans applies, so there's just no debate whatsoever. So that concludes the debate on the ukufakwa custom as a possible basis. We know that ukufakwa was mentioned in the letter by Prince Thembi of the 3rd of June, but it was never alleged that Prince Misuzulu at the time was not identified in accordance with custom, nor was it alleged that the ukufakwa custom has meant that the order of succession has changed. Never alleged. And when the matter was before the judge, Judge Davis, the evidence that was there was clear that A, the custom was never performed from a historical memory perspective. Secondly, it did not meet the requirements of custom from 2 expert historians. So that then leaves only one issue, which is the question of res judicata and the issue estoppel. Now again, Judge Nichols, this is not a defense of my heads, but it's just to show that on the recognition decision, which starts at paragraph 45, we do expressly rely on the res judicata principle as a reason why you should not interfere with the recognition decision. What we say is simply that it's dubious whether it's applicable in a dispute that is governed solely by custom, because of all of those cases that say customary law disputes must be resolved by the application of customary rules. But insofar as the recognition decision was concerned, which is an administrative action, we submit that the res judicata principle applies. Now, here it's quite clear that the Prince Mbonisi was an applicant, and what he sought was an interdict in which he had to show either a clear right or a prima facie right, even though open to doubt. And showing that right necessarily meant that he had to explain what was the basis of the unlawfulness in the decision by the president to recognize. Because he sought an interdict to prevent the recognition in the future. Now here, of course, he's dealing with a review, but it's the same issue, because the basis for the interdict was that the royal family was not properly constituted. That was the basis for the interdict. The basis of the review is still that the royal family was not properly constituted. And that issue is dealt with fully by Judge Madondo. The judgment is volume 1, page 124. And where he starts by narrating what the issues are that he must decide. And that you'll find in the application of Prince Mbonisi. So Prince Mbonisi's, that starts at page 150, paragraph 67. And he then recites the order that he sought, which is at page 151, paragraph 68, point B. So what he says there, he says he seeks an order interdicting and restraining the 4th respondent from recognizing or undertaking any steps which may reasonably be construed as recognizing the 1st respondent as Isilo, pending the final determination of the applications under case number 2751, 2752, and those were the applications brought by the princesses. But what is squarely before him at that stage is a recognition decision challenged through an interdict. He then summarizes the issues at page 153, paragraph 78, and 2 are germane to the debate on issue estoppel. One is 78.C, Prince Misuzulu was legitimately and appropriately identified and nominated as the successor to the late Isilo, and D, there is any dispute as to the Zulu kingship. And then he deals then with this issue. Coronation is irrelevant, but recognition is relevant. 154, paragraph 82, 85, 158, 159, 160, 161, 162, and then finally decides the issue of the existence or otherwise of the dispute. So that question as to whether or not the identification of Prince Misuzulu then as king was squarely before him, it was squarely considered, it was squarely decided. So even on res judicata principle, same party, same cause of action. The only difference that has changed here is that the remedy is now sought under the guise of a review, but it's the same case. Now, so Prince Mbonisi would be bound entirely by the findings of Judge Madondo. You are then left with, well, what do you do about Prince Magade? The problem is that Prince Magade seems to have been there as well. If one looks at volume 23 and volume 23, these are the heads of argument filed on behalf of King Misuzulu. And you will see at volume 23, page 4494. 4494 at paragraph 133.7. It is stated as follows. On 21 May 2021, an order was granted requiring that any respondent supporting the application deliver an affidavit by 18 June 2021, and any respondent opposing the relief deliver one by 30 June 2021. Prince Mbonisi and Prince Simagade Zulu both elected not to file any affidavits pursuant thereto. None of the applicants saw it fit to file any supplementary affidavit dealing with the minutes of the meeting of 14 May 2021. And here we must distinguish, this is the case of Prince Mbonisi, not the case of the Queens that they are dealing with here. And you will see that at 4493, paragraph 131, where it says the applicants belatedly contend that the royal family was improperly constituted when the decision was taken, as the presence of persons other than the royal family rendered any decision related to the identification invalid, which is precisely the case that Prince Mbonisi raises, or the same cause of action, let me put it that way, that Prince Mbonisi relies upon. And Prince Magade Zulu is mentioned here by name, and even in the replying affidavit rather, in these proceedings. The only thing that he says is that I was not an applicant in those proceedings. He doesn't deny that he was a respondent in those proceedings. He says I was not an applicant. And in any event, I was not aware that the proceedings had been consolidated. These three applications were consolidated. But he was there, he was a respondent, he had a chance to participate if he wanted and to raise his issues. So issue Estopel then is laid against both of them. Same party, same cause of action. And even if the formalities of res judicata were not applicable, the underlying jurisprudential rationale of the issue Estopel is finality in litigation. There has to be a point where a case comes to an end. And we've referred the court in our heads of argument to, which is at paragraph 57 and 58, to a judgment of Mkhize of the Constitutional Court, which deals with this issue that the underlying basis of issue Estopel is finality in litigation. What is intolerable is to keep litigating the same issue. Now, if you look here in this case, what are the issues that we are dealing with? We are dealing with the validity of the meeting of the 14th of May, as to whether or not that meeting was properly composed or not. Judge Madondo has dealt with that. We are dealing with the issue of the succession as to whether succession was done in accordance with customary law. Judge Madondo has dealt with that. We are dealing with the issue as to whether there are any other contenders in customary law to the throne of the Zulu kingship. Judge Madondo has dealt with that. So there are no new issues that have arisen in the litigation before Judge Davis, which did not arise for resolution in the litigation before Judge Madondo. And so issue Estopel will say, well, even if we cannot say it's the same parties, but if it's the same issue and it's been finally determined, the rule of law requires finality on that issue. This issue has been litigated and it's been finalized. The Judge Akua knew this, he accepted it at paragraph 36. The problem is that the wheels came off when he was dealing with the recognition issue, where he then reopened the entire thing again. So that's why we would submit, therefore, that the principle of res judicata, alternatively issue estoppel, precluded the analysis on the second issue, because that entire issue of recognition per se had been closed. Now, it's true, Justices, that he did say you cannot challenge, any challenge now to the decision is premature. But that does not take away from the fact that the underlying cause of action was resolved, which is this done in accordance with custom? That issue was resolved.
So if now the identification issue was no longer before Davis Day in the High Court, was it open to him to review and set aside the recognition on the assumption that identification decision was in order?
Yes. Unless the only way to do it is to set aside the judgment of Judge Madondo.
Yes.
But other than that, it was not open to him. And here I must emphasize, it does not matter if Judge Madondo was wrong. What's important is that his judgment was factually extant.
And not appealed against.
Not appealed, yes. Well, they were late in appeal. They tried later, but that just didn't work. But it was not appealed. And you know this from the judgment of Tassima, of the Constitutional Court, which makes this point clear. A judgment may be invalid, it may be a nullity, but it exists, it has consequences.
Well, the only way in which you could have reviewed and set aside the recognition decision, if, for instance, if there was non-compliance with Section 8.3a relating to the publication of the notice in the Government Gazette.
Yes, no,
if
that I would
those procedural steps were not taken.
Yes. No, that I would accept, but what he could never do, what he was precluded from, was to rely on Section 8.4.
Yes.
Because Section 8.4 was expressly addressed in terms.
Okay.
That leaves only one question, which is costs. We ask that you overturn the decision, you replace it with a finding that the application is dismissed. We are private parties insofar as BioWatch is concerned. And so we would be entitled to our costs against both Prince Mbonisi and Prince Smagade. Unlike the president.
Okay, you appeal on behalf of the king.
I appeal on behalf of the king. I mean, I suppose there is a notional, is an embodiment of the aspirations of the nation, but he's not the state.
All right, point taken.
But what is the order that you would seek?
Well, the order here is the paragraph 66 of the order of the court of court is set aside. The application is dismissed with costs. It's replaced with an order that the application is dismissed with costs. And then there is this debate about whether, if you uphold the appeal, whether I'm entitled to my costs. But I'm saying I should be treated as a private party.
Yes, no, I understand that.
So it's we uphold the appeal, we set aside the decision of the High Court, and we substitute.
Yes. With an order that the application is dismissed with costs.
Yes.
Thank you, Justice.
Mr. Machine, it's your turn now. You've had a debate between the courts. And Mr. Moran and Mr. Zulu. So I'll give you time just to put your papers in order, and then we'll start with your 20 minutes.
Thank you, Deputy President and Justice of the Court. The applicant, sorry, the clients whom I represent are members of the royal family. They are here representing royal family, the Zulu royal family. That much is not disputed by any party in these proceedings. They are here to ask, or rather they are here to appeal a judgment in which they were denied a right which is conferred on them by both tradition, custom, and legislation. And that right is the right to be party to a decision that identifies an individual in the royal family who would represent the highest authority of that kingdom, the Zulu kingdom. In other words, they are here saying we were not given our right to identify an heir to the late king, our brother, as a king of the Zulu kingdom. That right is not merely a right that comes simply from statute. And I listened to my learned friend, and I hope I got him correctly when he suggested that the legislation which introduces the notion of royal family does not reflect accurately the position in customary law. Here is the most important point I wish to make right up front. And it is that if there is an allegation by a member of the Zulu royal family that the identification process excluded them, that the identification process was not transparent, that the identification process did not take into account essential and critical characteristics of a customary sound identification process. That is a complaint about a customary law not having been complied with. In other words, an identification process that has not been complied with is one where the royal family has not been given that right to identify an heir. So the most important thing about the judgment, insofar as it reflects on the issue of the existence of a dispute or of allegations, I'm going to deal with that later on, is that there is ample evidence in all the papers, in the volumes and volumes that we have, that the royal family's complaint is that they were not involved in the identification process, that they were excluded, that the identification process was opaque, it was arbitrary, and that they needed an identification process that complies with the tradition as they understood it. Now, that complaint fits squarely within a complaint about identification as set out in Section 8.4. In other words, in Section 8.4, there is an allegation that the identification of a person as a king, and then I can read was not done in terms of customary law. If the royal family was not involved, or if there is an allegation that the royal family, critical members of the royal family were not involved, that's a complaint that fits squarely within the Section 8.4. There is no conflation of statute and tradition there, because one of the assumptions what we must make is that statute reflects custom, because they are not inconsistent with each other. The royal family exists, and they are right behind us here. So it's very important to appreciate that a complaint under Section 8.4 that the royal family was not involved, or that certain members of the royal family were not involved in the identification process, particularly in relation to the meeting of the 14th of May 2021, is a complaint about customary law not having been followed, simply because the royal family says it was not involved. So that called for the president to say, okay, fine, there is now a royal, I'm getting a number of messages that suggest that there is a complaint about the royal family not having been party to the identification process. And that calls for the president to start applying his mind. But here is my starting point. If, as the president tells us, he took his recognition decision after consulting only the minister, and I understood my learned friend, Mr. Moran SC, suggesting that, or submitting that the Premier was consulted through the minister. We submit that that's erroneous. It is clear that his decision does not comply with Section 8.1b of the Traditional Leadership Act. If the president did not consult with the Premier, that's the end of his lawfulness of his recognition decision. In fact, the president tells us that he only consulted with the minister. And you'll see that in volume 6, page 1046 to 7, at paragraph 83, where he says,
Volume 6, sorry, page?
Page 1046, volume 6, at paragraph 83. So he tells us how he took the recognition decision. And he says, I waited for the support of the minister for my decision to recognize King-elect. Nowhere does he say, I waited for the support of the Premier for my decision to recognize King-elect. In fact, the Premier is not represented in these proceedings and was not present in the proceedings in the High Court. He has not filed anything to demonstrate his engagement or consultation with the president. This can only mean that the president did not consult the Premier. And the idea that it was left to him to decide the method of consultation, and that method of consultation was via the minister, does not accord with Section 8.4 of the Traditional Leadership Act. Section 8.4 identifies two functionaries that must be consulted by the president. Two functionaries. It gives him no option to consult one and not the other, because notionally on the approach advanced by my learned friends for the president could say, I waited for the support of the Premier for my decision to recognize King-elect, and say nothing about having consulted the minister. That could be wrong. So we say, apart from the fact that the High Court was correct to say there was a Section 8.4 problem, in that there were allegations that the recognition decision, the identification decision had not been done in terms of customary law. There is this problem that the president himself did not consult the Premier, and that should end the defense on the legality, on the lawfulness of the president's defense for his decision. Now there were references to the letters that were written that show that one of the letters the most important letter actually was the minister's letter when she was advising the president that after the judgment of Justice Madondo, that she was in support of what she refers to as the King-elect being recognized by the president. She says in that letter,
sorry, reference please, page number.
Yes, I will get you the letter. Just. The letter is in volume 3, page 572. Paragraph, so the way the minister speaks about support for the recognition of what she refers to as king-elect is paragraph 20 of that letter. It says, I support the legal recognition of the king-elect as the king of Amazulu kingship because of the court judgment. The Premier's letter of 5 August 2021 also supports the legal recognition of the king-elect. I must just pause there and then go to the letter itself, the letter of the 5th of August, and that letter appears on page 578. You will read that letter and you'll find nowhere where the Premier supports the position reflected in the minister's letter. So anyway, what happened there was that the President was not advised correctly. Because if you read that letter of the Premier, it may be important to read it. It says, following the demise of King Kutuluzwelithile Kabheka Zulu, as the Premier of the province, I received a letter from the traditional Prime Minister to the Zulu monarch and nation, Prince Mangosuthu Buthelezi, informing me that the nomination of Her Majesty Queen Mantombi Dlamini Zulu as the regent to lead the Zulu nation. In this letter, he indicated that according to His Majesty's will and the consensus of the royal family, Her Majesty was ready to be approached by government to arrange the formalities of her installation as the regent of the Zulu nation. Whilst the provincial government was preparing to meet the royal family, tragedy struck on Her Majesty the Queen, and she passed away on Thursday, 29 April 2021, after a short illness. Immediately after the planting and the memorial service of Her Majesty the Queen, the royal family met and her will was pronounced, and Prince Musuzulu was announced as successor to Her Majesty. Accordingly, this decision was reaffirmed by the meeting of the Zulu royal family as indicated in the minutes. Subsequent, I received a letter from Her Royal Highness Princess Thembi Ndlovu Zulu informing me about the nomination of Prince Magadi as the successor of His Majesty King Kutuluzwelithile Kabheka Zulu. Attaches the minutes. During the process of nomination, it became clear that the Zulu royal family is divided on the final decision as to who should be successor to His Majesty King Kutuluzwelithile. It must further be noted that immediately after the will of His Majesty King Zwelithini Kabheka Zulu was pronounced, 2 court applications were subsequently brought by Queen Sibongile Zulu against Queen Mate and others, and Princess Dandoyenkosi and Ntombizosuthu Dlamini Duma against Queen Mate and others. These 2 applications were issued on 28 April 2021 after the death of His Majesty King Kutuluzwelithile, but before the passing of the regent, Her Majesty Queen Mantombi Dlamini Zulu. The Provincial Executive Council has appointed 3 experts in mediation, Zulu culture and legal aspects to I'm not sure I can see that. De-escalate the problems, encourage the expression of all consent by the parties, while respecting the views of all parties and assisting them with finding a solution to the problem. These experts are Justice Ntsikelelo Phoswa, as the chairperson, Senior Magistrate Thembiso Maphumulo, and former Premier Mr. Willis Nkunu. When the minister says to the President in her letter of in her letter, when she says that there is support, the Premier's letter of 5 August also supports. There is nowhere where that letter supports the legal recognition of the king-elect. To the extent the president took this letter of the minister and the letter of the premier and read the two of them, he would have been able to see that the premier there's no way where he says he supports the election of or rather the appointment, the recognition of the king. So that letter, that is a problem that the president would have read the two letters and came to the conclusion that in fact there was a basis in culture and custom to recognize the king. But let me also reiterate something important, which the Zulu royal family said in the High Court and will say here, which was that they are not in court asking the court to recognize a particular individual as king. They are asking for the rights they have to identify a king. They are asking the court to endorse the customary position that as the royal family, they have a right to identify a king without any interference. As the royal family, they must be allowed to sit, consider the variables they need to consider, and to appoint, or rather to identify an heir that would be recognized by the president. So,
okay, you are 20 minutes out.
Yes, no, I should have waived my right to. I should have actually waived my right to not be asked questions.
My first question is on your last statement. You said that the royal family doesn't have a sort of a preferred candidate. All that they are seeking is to participate in the identification process. Will it not, well, let me rephrase my question. Surely, if they are saying that we are not given an opportunity to participate in the identification process, they must tell us at least to say, this is the person that we wanted. We did not want person number A, this is our preferred candidate. They can't just come to court and say, well, we want to be given an opportunity to participate in the identification process when they do not identify who it is that they want to nominate or identify. What happens if at the end of the day they say, okay, we agree that King Mrs. Zulu should be identified?
Deputy President,
would it not be an exercise in futility?
Yeah, no. Well, but let me answer the first question, the first part of the question. The identification process after the death of a king is a very sacred process. As we explained in the founding affidavit of the applicants in the High Court, it is a process preceded by a series of rituals. It is an important ritual that is conducted by the family. They never want to play out this show here. Is not what the royal family would have wanted. They would not have wanted the matter to end up in court, to end up with all these fine lawyers making these submissions they're making. They would have wanted to have the time as the royal family to engage with the duty they have, which is to look at all the variables they need to look at, including whether or not the will of the late king, Goodwill Zolitile, nominating the Queen was something they could give effect to. In other words, the ultimate authority on the identification process is the royal family. They would have known that the king is not.
But at least here, that is not the basis upon which this matter this appeal is being pursued. It's pursued on the basis that there was compliance with customary law and custom in terms of identifying the king. They are not basing their claims solely on the will of the late king.
No, maybe
the will of the late queen.
No,
That
President.
case is anchored on identification of the king in accordance with customary law and custom.
Yes, and as I've made the submission that the primary case is that it is customary law for the royal family to identify an heir.
All right. That
So if they are
next
denied-
question to you- sorry. My next question to you is, which part of the royal family members wanted to participate and were not afforded an opportunity to participate because, according to the minutes of the meeting, some invited, and they responded positively to the invitation. Others did not. They sent their apologies.
Yes. Let me start with
Including your client.
Yes, let me start off with what my clients wanted in the High Court. If you look at volume 1, page 2, that is the notice of motion.
I know.
They were clearly attacking the meeting of the 14th of May. They were attacking the decisions taken on the 14th of May, and they wanted the right to be given to them to identify an heir.
Prince Mbonisi is the first applicant in that proceeding, is that correct?
Is the brother to the late king, yes.
Well, but Prince Mbonisi is the first applicant in those proceedings.
That's correct.
Prince Mbonisi, there is an allegation that Prince Mbonisi was invited to the meeting of the 14th of May and he declined. So, and then he comes to court and says, I wasn't given an opportunity when the opportunity was extended to him and he did not make use of that opportunity.
You know, sorry, President, here is a problem.
Yes.
If you read the papers, which you obviously have, you will see that the meeting of the 14th was originally a meeting for the performance of a mourning ritual in respect of the passing on of the late queen.
Yes.
So the family was meeting to perform an important ritual, a mourning ritual. Prince Mbonisi tells us that not everybody goes to that mourning ritual. Not everybody goes there. Some people don't go to the mourning rituals. Prince Buthelezi tells us that when he looked at that meeting, he realized there was a lot of people who had attended the meeting. And that's when he decided, no, there are many of the members of the royal family. Let's have the identification meeting on the 14th. So you will appreciate that firstly, you can't commingle these two occasions. You cannot commingle them.
So are you saying that the Zulu royal family was not involved in the identification meeting of the 14th?
Yes.
Is that what you're saying?
That's what I'm saying.
So why send apologies to that meeting?
No, because the meeting of the 14th was a ritual, a mourning ritual. Remember, if perhaps I should go to the affidavit of Mbonisi, of Prince Mbonisi himself, where he discusses the meeting of the 14th.
What? So you're looking for that?
I'll find some.
Are you saying that there were no members of the Zulu royal family there?
And here is another big issue, Justice Asante. The definition of the royal family. The royal family is a big family, and there would be people in the royal family who are close enough to issues related to the throne. Not everybody in the royal family participates in the succession or in the identification of an heir. Not everybody. There are specific members that one of the very close members that must be involved in the identification of the heir are the brothers to the late king. But there will be other members of the royal family because it's a large family. And you will see, because it's a large family, you have to define the meaning of royal family. That is the power and the duty to identify an heir by understanding how that royal family, and I'm not saying the Zulu kingdom, I'm saying the royal family. It's a family. How that royal family allocates specific tasks to specific people. So in the identification, for example, when Bonisi tells us that Amazinyane, the children of the late king, do not participate in the identification of an heir because they are potential beneficiaries.
Why do you say that is a function of the uncles?
Yes, the function of the uncles.
Okay.
And the queens do not participate in the identification. They've got advisory, they can be consulted, because there are a number of variables that must be considered when an heir is being considered.
And the houses of the previous kings, aren't they participating in the identification? Because it seems to me the evidence is to the effect that the houses of the respective previous kings were present at that meeting. The house of
That's
Tekwayo, the house of King Zulu, the house of King Solomon, the house of King Beki Zulu, and the house of King Zoliti. So those respective houses were present.
Just on that, Justice Paswan, just on that, we can go to the meeting of the 14th of May. You will not find that identification.
Are you referring to what?
To the minutes of the meeting.
register?
Yes, you will not find a discussion that the houses of the royal family who are represented in the identification meeting are so and so, and they belong to these great kings of the Zulu kingdom. You can go to the
So your submission is that these respective houses were not present at the
yes, because that they would have reflected in the minute. If we go to the minute of the 14, let's take the minute.
What page? Just remind us.
It's volume 4, page 723. Okay, it's also that minute. Right, so you'll see that on page 724, there are comments by members of the royal family. And there is Prince Guyana, Kapeto Muhle, Kasolomon Gadinuzu. There is Prince Vanara, Kambuzini, Nyaiza, Kandabugo, Kampande. There is Prince James, Kamzi Yakoga, Kampiga Nina, Kaziwetu, Kampande. There is Prince Menzi Katanda Yipiga Solomon. There is Prince Langaletu Kapego Zulu. In fact, so what I'm asking really is for the court to look at what is said about the number, because I know that in one of the affidavits of Prince Buteleli, he says there are 5 kings that ought to be represented in that meeting. if you go to the identification meeting of the 14th, we do the exercise of trying to figure out who exactly in that meeting represented the 5 houses of the royal family. And over and above the other problems relating to the minutes, which the presence of people who are absolutely not members of the royal family, and we'll take you there to just prove that even if you were to find maybe 3 members of the royal family that are identified as the core group that can be involved in the identification of the king, the presence of people who are not members of the royal family would create problems for the lawfulness of that meeting. There's a case in the Constitutional Court which specifically says that.
Well,
So-
their presence per se, I don't think that it will invalidate the meeting unless they participate in the identification process. But their presence per se,
But you will not find the president
yes.
a minute that tells you who said what, who said where, except to the extent that it's summarized. So the question must be, is a family seeking to identify an heir? Is it a meeting of the family seeking to identify an heir? To have people who are not members of that family sitting in that meeting? And it's not even clear what the extent of their involvement in that meeting was. And when there's a complaint by the brother of the late king, or the brothers of the late king, saying, no, wait a minute, we've looked at this, it doesn't accord with what is supposed to be done when you're identifying an heir. Surely you've got to accord the brother to the late king some status, because that's the closest you can get to somebody who has an interest in protecting the crown.
The brothers who wanted to attend but were not, according to the population, were not afforded an opportunity to do so. Who are they?
No, all the applicants, President. Most of the applicants, I can't tell you
Okay.
which brothers, but all the brothers that are applicants did not attend that meeting on the 14th. And bearing in mind the primary complaint that they bring, which is that Prince Viteles was not entitled to micromanage the identification process, because he is not a member of the royal family with the right to identify an heir.
Well, but this is not what he says in his affidavit is that from time immemorial, that has been his function to call the meeting.
It's disputed. It's disputed because now it's a family. It's a family saying, it's a family now seeking to identify an heir. The family says, we can't have somebody from outside telling us.
Is he from outside?
No, he's not a member of the. He's a member of the royal family, as you would appreciate, President, through Princess Margot,
Yes.
through his mother.
In other words,
But he's not
from the ruling house.
He's not from the ruling house. He's not. He would not.
So his mom is he not related to the king's father, late king's father?
No, they're obviously related. I suppose you are just asking a question for me to answer it like that.
Yes.
They're obviously related. Yeah.
So are you saying
I'm
that,
not sure what.
So doesn't that give him authority to participate in the meeting
No.
and to call meetings?
In the absence of a direct brother of the late king, in the absence of direct relatives of the late king,
Is it an
that seems onerous.
established? Is it an established custom? Because I just want to understand the notion that there should have been members of the royal family, and because that meeting was called by somebody who is not a member of the royal family, that meeting was unlawful. So, do we have a practice in terms of which somebody has been identified as a person who is responsible to call the meetings of the royal family members?
So Prince Viteles is correct that he is historically been the spokesperson of the king and the kingdom. What is contested by the family that must identify the nephews or the nieces, the family that must identify the family members. What is being contested by that family is that he, Prince Buthelezi, even as Prime Minister of the Zulu Kingdom, had the right, anchored in custom, to call a meeting and for the purpose of identifying an heir. That's like the highest a family can ever have. A family wants to be given the space to actually identify an heir. And if somebody else from outside the family, who is part of the family but is a distant relative, micromanages that in a way that excludes others, it's a problem.
But isn't the whole process clear that it's the firstborn son of the Queen and the late King? And the only question is it the adopted one or the biological one?
Let's test that, Justice Nichols. Firstly, one looks at what happened when His Majesty, the late King Goodwill Zwelithini, passed on. There is a will that identifies a queen. Now, if we go with this custom that is being that has been mentioned as a custom that predetermines who the heir is, we have a problem, because the head of the Zulu royal family, none less than a king, did not identify an heir who was his first son. Identified the queen.
Sorry, I'm not with you, Mr. Now.
So I'm saying, I'm trying to test the validity of this culture where the firstborn of the great wife is predetermined heir to the throne. I'm saying on the facts.
Are you disputing that?
Yes. On the facts of this case, the first thing that I invite the court to do is on the facts of this case. The king passes on. If the king would have known that he bore a son as king to replace him when he goes on, doesn't endorse that position of great wife, predetermined king. What he does is he writes a will. If that will is said to be valid, but there is that will, it writes a will where the throne goes to the queen. And let me debunk this story. If you read the will, it does not create a regency, because there was no point in creating regency. The only time you create a regency is when there is a minor. The king was not a minor when his father passed on. The king was already in his 40s. He was already old enough to assume the throne. But what happens is that his mother takes over, and there is a story about how she ended up becoming a regent, according to the papers. Buthelezi tells us, well, this was a regent. The will that gave her the position says she's a queen. She's actually the leader of the Zulu kingdom. It was not a regency. But what the queen does, and you'll go to the letter of the queen, and you'll see that she writes a letter to the Prime Minister and to the royal family. And in that letter, she's very careful not to usurp the role of the royal family. She says, I want to give up the throne. I'm happy that the king thought I could take the crown. I'm grateful for the trust that they have been given by the king, but I want to abdicate the throne for my son. Now that also tells you that this great wife, predetermined heir to the throne, is not in accordance with custom, because these are the two people you must understand represent the purity of the custom.
Then what is the custom? If it's not predetermined by the firstborn child of the great wife, then what is the custom?
Then that's when you need to give the royal family the opportunity to sit down.
So the royal family could choose anyone?
No. They could just choose anybody. The royal family will look at all the children that are eligible for the position.
So they look at the children.
Yes. It's the
Mr. Mafuta,
children.
but surely there must be a custom which is going to guide them in terms of identification. And what is the established custom? Because surely there should be an established.
No, it's dealt with in the papers by policy. It deals with it extensively. What the custom would be. And it firstly tells the president about the custom that they still need to follow as a royal family, which he says are these rituals that ought to be done, because of all those customs. Sorry, President.
Well, those were they really necessary before an identification process is undertaken, because the meetings were held left and right and center, despite the fact that according to Prince Mbonisi, ukuhlamba kwesihlalo, cleansing ceremony, some cleansing ceremonies had not been performed. But
if there's anybody who must visit,
a number of meetings were held and decisions were taken in those meetings, despite the fact that those rights have not been, customary rights have not been observed.
if there's any group of people you must listen to, is the royal family, about what they need in order to identify an heir. And Prince Mbonisi deals with that aspect in his affidavits. Part of what he says is that the royal family must prepare for the identification process. Now, of course, when you are not part of the members of the royal family, it looks very unspiritual or whatever. But the reverence, the importance of the identification process is preceded by spiritual activities. Religious activities, you want to put it that way. Rituals that are very key to the belief system of the Zulu family. You can't belittle them or simply wish them away and say, well, do you need to actually have those meetings in order to identify and this is the mistake that was also made by Justice Matondo, when he says it doesn't matter what the will of the late king says or what the late queen's will says. He disregards those. He says they're important, but he disregards them. And that's the importance of leaving the matters to the royal family. Because the royal family's approach to identification is that where the king, the late king, expresses a view about who he would want to be the king. According to Matondo, that is binding. It's almost like very difficult for the royal family to deviate from. So but they must know that the late king had a particular view about his succession. And when they do, and they sit down as a royal family, they discuss that. And if they are going to contradict what the late king's will was, they have reasons for it. And that's why I'm saying, and I'm going to deal with the Justice Matondo's statement. That's why I'm saying the royal family's duties cannot simply be looked at as a mechanical sort of duty where the king dies, then there's a succession, and then there are meetings that are held, and the successor is pulled out of the head. No. It's approached with reverence.
So, Mr. Masuka, are you saying that without these certain ancestral spiritual rituals, any identification process would be invalid?
No. The identification process that must be done, the people who must identify an heir is the royal family. So the royal family must decide how they want to identify an heir. That process is their process. I'm not saying that they are strictly bound to follow certain, or if for example, they don't follow a certain ritual, then the identification that's done prior to that ritual is a nullity. They would consider it quite an affront to their own identity as a family. They would see that as an identity crisis, because they would be asking questions, why was this not done? Is Godo as Standwan? What does that mean? Does it mean we put a king when there was still a dark cloud of death in our family? So I'm saying the importance of leaving the identification to the family cannot be overemphasized, because they will decide what is important in the identification process.
Well,
And they're key.
But at the end of the day, Mr. Masudu, that identification must be in accordance with custom. Is that not so?
Yeah, that's an obvious statement. Yes.
Well, what is the custom when it comes to succession?
So I tried to explain that custom, Your Lordship. I mean, President said that that's not necessary for that customs to be done. I explained that prior to the identification of an heir.
What guides them in the identification process? That's maybe my question did not come out clearly. What guides them in undertaking that identification process?
Firstly, they are presumed to know the heirs or the children of the late king, each one of them. When they sit down to say, okay, who must then take over from our late brother, they engage with that following a number of factors, one of which is from which house, one of which would be the age of the particular individual. For example, if the heir, potential heir, is not of age, cannot assume the kingship because of one or other reason, like they king, then a regent is appointed to take.
Well,
but there is no textbook.
Let us be specific, Mr. Masoga. You've got a situation here where you've got about 6 or 5, and then there's a great wife. What does the custom tell us when it comes to selection of an heir upon the death of the king?
But that is the
situation where there's a great wife.
As you know,
you can't avoid that question, Mr. Masoga.
No, I'm not avoiding it.
Okay.
I'm going to deal with it.
Yes.
I'm trying to deal with it.
Yes.
If you let me deal with it, I will.
There is a great wife who has been identified, and everybody understands who the great wife is. What does the custom say when it comes to succession?
With specific reference to this case,
yes,
you will appreciate that the notion of a great wife is contested.
I'm not sure.
It is contested. There is a great deal of discussion about the idea of a great wife who is known only because of a relationship with the royal house in another kingdom. Prince Mbonisi deals with that aspect in extensive detail in his affidavit. Can I refer you to 1337?
It will seem to me that for all intents and purposes, the late queen was regarded as a great wife. Because
what would be the evidence of that, my late
Prince Simagate is saying?
No. Mbonisi, the father of Simagate, says differently. He says differently. Who are we going to believe?
And Prince Mbonisi, she left the king and went to stay as Swati.
No, my lord, with respect to the president, the deputy president.
Yes.
I think we've got to be fair to what Mbonisi says about the notion of great wife. I'm trying to refer you to a paragraph or paragraphs where it deals with the notion of a great wife.
All right.
Because I think what you are saying now does not deal with the great wife issue. The great wife issue is debunked at the level of, firstly, a great wife is introduced as a great wife to the family.
That's what
it's
not
not Yes, it's not. There is no evidence from the brothers of the late king that the queen was in fact introduced as a great wife.
All right. So
the only reason why she is regarded as a great wife.
The submission here is that there was no great wife.
Yes, that all the queens were on equal standing.
Okay, just make another thing. There was no great wife.
And what about the settled custom that Advocate Nkutobi brought our attention to, that any queen born of royalty takes precedence over the others?
No, so a great wife is appointed by the if I may use the word loosely, husband.
Yes, no, I'm asking you, what about the settled custom?
You say settled.
Yes.
Yeah,
Is it
but that's what I'm
settled?
contesting.
You don't accept it.
No, that's what I'm trying to
And the
explain.
second one is the fact that the lobola is paid by the Zulu nation.
All
Gives,
the queens,
an edge over the others.
all the kings, queens, the lobola is paid. It's paid.
It's paid by
Can I ask the question? Where in the papers are you asking me to refer you in order for me to support that proposition that you're putting to me? Where in the papers you have a confirmatory affidavit saying here is a group of people that went to Eswatini who negotiated the lobola, and this is what they said was their mandate when they went to Eswatini to deal with that aspect. It's all said by Prince Buthelezi. That's what he says.
So we should ignore the evidence of Prince Buthelezi.
No, I'm not saying you should ignore it. What you should
What
do
is
is you
happening
test
now?
it. Test it against what the members of the family that wants to appoint an heir, say. Test it against it and see whether or not it is correct to suggest that a princess from another royal family who marries into the family of another royal family immediately assumes a position of a great wife. Test it and see whether that is a tradition that was understood by anybody. But you will not find the evidence that you are looking for, where somebody went to Eswatini on the instructions of the Zulu kingdom. The chiefs that went there, that we understand went there, and they negotiated the border, and then there was that exchange which signified marriage between the two kingdoms.
Yes, so
No
your
confirmatory
submission is
affidavit.
that there's no settled customary
It's not a
law
settled
on
custom.
that. Yes, no, we'll make a note of that, together with your submission that there was no great wife.
Yes, and if you look at volume 7,
Okay, let's go there.
from page 1337, 1337.
Yes.
And this is a replying affidavit of Prince Mbonisi to
No. The plan affidavit to Prince Simarati.
Yes. He says, I must first highlight that the position of the great wife is one which is earned.
Where are you reading from?
Paragraph 14, page 1337.
Yes.
I must first highlight that the position of the great wife is one which is earned and does not occur automatically by virtue of being a first wife or even by virtue of being from another royal family. In Zulu custom, it is only the king who appoints one of his queens to be a great wife. As the report states, Cetshwayo reigned as king from 1973 to 1994. He was the son of Ngumbaza.
So that statement is it correct, Mr. Masuzu? Cetshwayo reigned as king from 1973 to 1994. Not sure about the statement.
Yeah, no, I think that there may be. I think you're right. You're correct. You're correct. It's an error.
Should be 18.
But you can see that it's an error because the very next paragraph says the actual reign of King Cetshwayo was 1873 to 1879. Does that sound okay?
But you say in paragraph 14, it is only the king who appoints one of his queens to be the great wife. Did the late king not appoint the late queen as the
because
great
the brothers
wife?
of the king would have known. It's not a private affair. Appointing a great wife is not a private affair. So it says the circumstances under which a great wife is further.
So now, if that is what you are putting forward, Mr. Masudu, why then was Prince Simagata affiliated to Queen Mandu?
You know, President, Deputy President, I'm going to ask that that question is answered by this Magate team.
We're talking about the people from the same family. You can't have a situation where one says this and the other one says that. You are confusing the nation.
No, we're not. We're trying to clarify the issues.
No.
You want President, you know that the royal family accepts entirely that Prince Magadi is eligible to be identified as an heir. But the royal family must do that.
And you say that Ugufagwa is
for them,
irrelevant.
It's irrelevant. What Fagasiswini and all the other...
It's completely irrelevant. Okay.
It's irrelevant. He is the son of a king. He can claim his lineage and heritage to a king. And that's what gives him the right to stand as an heir, potential heir. And that's what the royal family is telling us. It's telling us that we don't even want to be confused about Fagasiswini and all those kind of cultural adoption methods. The issue is from the perspective of Prince Monises and the brothers, is that Prince Smagate was not didn't go through that process of Fagasiswini. He was accepted as a son of the royal family, and they would.
So Prince Smagate did not go through the process of
Fagasiswini.
That's what you are saying.
Yes. One thing is he was accepted by his father as a son. And so he had a home in the family.
I'm confused now because that's a basis upon which he claims entitlement to succeed to the throne. Now you're saying that custom was never performed.
Yes, no, the brothers to the king are saying, and I would trust the brothers of the king. They will not exclude Prince Magadi from being considered as an heir on any basis. They will consider him as an heir, potential heir, because he is the father of a king, their brother.
Son.
Sorry.
Father.
Yes.
Son.
Yeah, no, I guessed
Let's
late
go
in the afternoon.
Let's go to the letter which Princess.
Sorry, I'm not hearing you.
So, Mr. Masuku, I just want to get it absolutely clear. He's a potential heir, but it's not on the basis of Ugufagwa.
No.
And Ugufagwa is irrelevant to this case.
As far as
completely irrelevant to
concerned,
this case.
He is the son of a king, their brother. And his standing as a son of a king entitles him to be considered as a and perhaps just to close down on the issue of the great wife, I've just been handed a reference to which comes from volume 24, page 4694. Page 4694. Well, it will start in page 4693, paragraph 14. And this is an expert historian, Simon Jabulani Mapalala, says, in terms of Zulu customs, the wife born of royalty and for whom Iloboro is paid for by Isizwe, the Zulu nation, is the bearer of the king. Historical records bear this out. The custom was recorded in the Court of Natal Native Law, Civil and Criminal, framed under the provisions of Section 4 of Law 44 of 1887. It says succession and inheritance in the families of hereditary chiefs in charge of tribes are determined in like manner as with commoners to the house of the chief wife. The chief wife of such chiefs is generally taken later in life. Helobolo is usually made up wholly or in part by the tribe, and their status publicly announced.
But I'm not sure if this supports your argument, because if you go to paragraph 12 or 11, it says this, the successor to the king of the Zulu nation is a matter dictated primarily by Zulu custom. An heir to the throne is not voted for but determined by birth. Zulu custom prescribes that an heir to the throne should come from the offspring of the king's great wife.
No, so that's where the dispute is.
But I thought you were referring to this as support for your argument, which it seems it's not support for your argument.
No, it doesn't support my argument in one way, but where it supports my argument is where the requirement that a great wife is publicly announced. And here are the brothers of the late king telling us that there was no public announcement on a great wife.
Well, who pays Lobola for it?
No, but so we must find out if there is any evidence.
Sorry. Surely somebody must have been part of the delegation.
But Deputy President, who paid Lobola for all the king's wives? That's exactly the point I'm trying to raise. That why are we trying to fit in something that the brothers are telling you that this process of a great wife is one they would have known about. It would have been announced. And in fact, they go further. They say the position of a great wife would, in fact, if it was taken the way it's being taken, it would be greater than that of the king, because the king is appointed. Is appointed. The great wife simply walks into a family and becomes a great wife, and from then on, then a great child must come from that scenario. I'm saying it's not a settled issue. And because the brothers of the family are telling you that the king, the late king, treated his wives all the same. He did not have a great wife. There would have been a public announcement that she was a great wife. Of course, they recognized the fact that she was coming from a royal family of the Swati kingdom. They would have recognized that. But it would not have granted her any status higher than the first wife or the first queen, the second queen, or the third queen, or the fourth queen, as far as this particular family is concerned.
Why was she named the successor in his will?
Well, we could ask, but the person who would have nominated as late king.
That's a question that I wanted to put to you, Mr. Masu. If you can just go to the will. What page is the will of the king, the latest one? Okay, let me see if I can get it. Okay. It's one at 103.
Well, volume 1.
Hey, the quality of coughing is very poor. You badly read.
Yes, that's the.
No, I don't know what that is.
So it's a. Sorry, madam. Is the paragraph you are referring me to be a paragraph?
Paragraph 15. Succession to the throne.
Paragraph 15. Yes. So there, of course, there is no mention of a great wife.
Yeah, proceed, Mr. Masoga.
And of course, you will see that if you look at the will, it tells you how he in page 105, paragraph 6, he says, in my lifetime, I got married to 6 queens as my wives. In each instance, I had consummated my marriages according to all of the 3 marriage systems, and some of them. Each one of the queens is allocated a palace, which for all practical purposes is a permanent home, and I remain the head of the palace. So there's no where he identifies one queen as being the queen who must bear an heir to the throne. And to be very clear, this is something that would, of course, if the late king had.
Sorry, can I go to paragraph? It's page 114. That is the first will. Paragraph 15. It's difficult to
114.
Is it paragraph 16 or 15? It's 16. 114. I hereby nominate failing Queen. I can't wait. Queen. We have the original.
So it says, I don't have the original, but I think it would be. It says.
Can somebody assist us with the original? We've got a better copy at least, because it's important for us to establish this. Page 114, volume 1. I don't know whether this with the Queen or what.
I hereby nominate and appoint. Would say that would be Queen as my successor.
Queen who?
It's common knowledge that it was actually Queen Mandom that was nominated. No, nobody disputes that.
Mr. Musoko, I'm not sure if you've answered my question.
We'll try and get a clearer copy, President.
I'm just not sure if you've answered my question. I said to you that if there wasn't a great wife, and you've said that he married 6 wives and he treated them all equally, what do we make of the fact that he did appoint her as successor to the throne? Does that not mean anything?
So that debunks 2 things. Before I get to speculating why the king would have nominated his queen, it deals with 2 aspects, that question. The first one is that the king by birth theory is not there, because the king, if he understood that his son was a predetermined king, would have immediately appointed him. He was already old enough to be king. The fact that he didn't appoint him tells you that there was no predetermination on who the king should be. But the second one is that the king could have chosen anybody to be a successor. And in this case, he chose his wife. There is nothing more that ought to be read into it. He could have chosen his 6th wife or his 2nd wife, or could have chosen even the current king as a successor to the throne.
So he could have chosen anyone. He could have chosen me.
No.
I'm no longer what
No, with respect, I'm sure you understand what I mean.
No, but would it have to be a wife?
Queen firstly before you can be chosen.
So you accept that it would have to be a wife?
It would have to be a queen, and there's 6 of them. He chose one of them. There's nothing special about we can't read into that choice the existence of a great wife. which I think is an attempt to, that reading is being read into it. But we shouldn't read that, because, as we say, the brothers to the king would have known and experienced the public announcement that this wife ought to be treated specially, because other than being the bearer of a king, is actually the great wife.
So your submission is that everybody is entitled to raise his hand, their hands, and say,
Everybody would be, you would mean everybody in the royal family?
Yes.
Yes.
Sons and daughters?
Yes. Because you've got to ban the customary primogeniture requirement to choose a worthy successor, and it could be a daughter of the king.
All right. In this case, what part of the custom was breached in the identification process?
Firstly, President, the meeting of the 14th was a meeting which was called for the ritual cleansing. It was a meeting for the royal family to mourn. On that meeting was piggybacked this identification meeting, which in itself was not an identification meeting. If you go to the meeting itself,
Well, but
it was a meeting in which the king was introduced.
sorry. The meeting cannot constitute culture. It's something else. The meeting. The culture is something according to which somebody is identified. So I think that we have to make this thing clear. The culture is a process, or it's something according to which somebody is identified.
Yes.
It can be a meeting, it can be.
And I have said to the court that the first issue, and this I said was a very important point, is that culture would point to the royal family as the decision maker on the identification process. The decision makers, as far as the identification process is concerned, is the royal family. It's not anybody else.
Well, but the royal family is an institution, Mr. Masudi. But the process of identifying a person who is going to be a king, it's something that must be done in accordance with the custom. So you need to identify the custom first. Once you've identified the custom according to which the nomination process takes place, then you say this particular custom was breached, and therefore the identification decision was unlawful.
Yes, but I'm not sure whether you, President, you are suggesting that my answer, which is that as part of culture, the identifier of an heir is the royal family. So the first thing that happens, the royal family sits, and the royal family must be identified. They then say,
in accordance with custom.
yes, part of the custom is
What
the royal
is
family.
the custom?
So the first custom, the first element of the custom is the royal family coming together and meeting.
Right, and then
Because nobody else identifies except the royal family in terms of custom.
But that identification process, Mr. Masudi, must be in accordance with culture.
Yes, it's in accordance with culture if the royal family has identified the heir.
Yes, what is the culture?
But
What is the custom?
That is what I'm baffled by with respect to President, because you insist on me answering the same question the same way.
No, it's not.
The same answer I'm giving you is this. The
The royal family is an institution. Okay, the institution, but that institution operates within a certain culture, custom. When it does things, it does those things in accordance with the Zulu custom. So my question to you what is the custom when it comes to identification of the king?
Right. So
We've identified the institution so far that the institution that is tasked with that obligation is the royal family. It's an institution, it's not a culture, the royal family.
no, but you see that is where I have a difficulty understanding how you edit out the institution itself has not been part of culture. Can anybody identify an heir? If, for example, a church came and identified an heir, would that be in accordance with the culture of the family? It wouldn't be.
Well, granted.
So I'm suggesting to your lordship, and I'm submitting to your lordship, that you must accept that culture points the royal family as the institution that must identify an heir. What happens when the royal family has met and now they're considering who the identified person must be? I pointed out right at the beginning that the royal family, as explained in these papers, would have conducted all the rituals that are necessary when they sit down to deal with the actual identification of the heir. And it's dealt with respect in volume 9, page 3491, from paragraph 29. When they sit to then talk about who should be identified, one of the questions they would ask is, one of the questions the royal family would ask is, if there was a great wife publicly announced, or if there was an heir already preferred by the king, they would start there. The king prefers this particular individual to be the king. There is evidence of the king, or the king told me as the brother that the person who must be identified is so and so. Then the royal family will say, okay, if the king says this is the person, the king's word as the head of the family must be given effect to, and that's what they do.
So your submission is that there is no established customary law and custom in terms of which the identification process is undertaken.
I'm not sure what your lordship is actually looking for, but here is my final attempt at answering the question. The royal family meets. They then do a will. Do we have
forget about the will, because the will.
No. I'm saying to you, because I'm trying to answer your question about what happens when the royal family is met. When the late king has identified a person that the royal family, that he says the royal family must identify, then the leader of the royal family, at that point, in this case it would be the eldest of the royal family, in this case it would be Prince Mbonisi, would say, I'm aware, because the king told me that so and so should be identified as an heir. Then a number of members who are present will say, okay, if that is the will of the king, what must we do? We must give effect to it. Now, I don't know whether we are shutting Buzi or wins one after that. No, all I know is that the royal family sits and they discuss, they identify the heirs. These are the heirs of the king. And we break it down quite easily as well, because we say when the king has identified an heir, the discussion is easier for the royal family. When the king has not identified an heir, of course, then the royal family sits and decides, firstly, to say who are the members of the royal family who are eligible to be identified as heirs to the throne. And some of the heirs or some of the children of the late king would perhaps not be known, but known by just a key group of people within the royal family. So they would know of a son who is in another province, who is supposed to be identified as an heir. So that's when they discuss the.
But you see, I think that we need to be loyal to the legislation, Mr. Masosi, which is Section 8(1)(a). You see, it says the royal family concerned must identify a person who qualifies in terms of customary law and custom. So that identification process must be in accordance with customary law and custom. So my question to you, to your knowledge, what is the established customary law and custom when it comes to identification of a king within the royal family.
So can I then refer your lordship to, sorry, President, Deputy President, to volume 9, page 3491.
Okay.
Volume 9,
Page 3491.
349.
And this is
Volume 9, no. 3491.
Oh, I beg your pardon. It's volume 18. I put the volumes together, so volume 18, page 3491.
You are there?
So if you look at paragraph 29, so it's procedure in the identification of an heir. Paragraph 29,
29.
and up to paragraph up to paragraph 40.
Yes.
So principle deals with the what happens, what the procedure in the identification of an heir is. But I'm just really want to emphasize the point that it is customary law that the royal family identifies an heir. So an identification that is in accordance with customary law is done by the royal family.
And that customary law, what does it tell us?
It tells us that the royal family will decide amongst the heirs who should be identified as an heir.
No, but that person who is identified must meet a criteria in terms of section 8(1).
I understand, I appreciate that.
Yes.
But that person who is identified, the criteria that he or she meets must be that is must be a son or daughter of late king. And it really doesn't matter. And sometimes, okay, there are certain instances where, as in this case, where the 13 houses of
irrespective of the ranking of the house in which that person was born.
If there's,
let's say there are 3 houses, 1, 2, 3, so anyone from any of these houses can.
The criteria is there must be children of the king.
Well, that's what I'm saying. There are 3 houses.
Yes. Here there were 6.
Well, okay, for sure, fair enough.
Yeah. So any of those children who are sons of the king are eligible for identification. I can see no cultural basis for excluding others.
All right. Well, I think that I exhausted the identification point.
Yes, so we will also realize that in that same affidavit, there is a great deal of amount committed to explaining who the royal family members are, with the duty to appoint or to identify an heir. We say that within the royal family there is the ruling family, which is the family of the king. And that is why where a king has identified a particular individual as the successor, the royal family would consist of the brothers and the sisters, would immediately give effect to that particular, would seriously consider giving effect to the king's to the king's identified heir, because he's the head of that house, and because the royal family respects the head of the house. And what he says is considered quite important by the royal family. And this is why, for the royal family, and this is context in which one must understand the Bonis's, the President Bonis's involvement in the case, right from the beginning, because he understood that as a royal family, they would have to contend with things like the wills themselves. If the wills are pointing them in a particular direction as to who should be king, they would have to be considered by the king. And so when there's a dispute about the wills, you would have wanted that to be resolved first before the royal family sits to actually decide on who the heir is. And that was sensible to actually do. So, and then there are many. Let me just reorder the way I wish the court to appreciate the application of Prince Mbonis. It was an application to review and set aside the identification decision, and the basis of it is set out in our heads of arguments. One of which is that as the brothers to the king, they were not involved in the process of identification. And secondly, if you look, one looks at the meeting of the 14th, which is the meeting which was called against him on the back of a meeting of the royal family, which was performing a morning ritual. You will see that a number of those people who were in that meeting were not members of the royal family. So if one would deal with that in volume 9, from where the deficiencies are, which points to the unlawfulness of the meeting of the 14th. From it's volume 9, page 1665, paragraph Actually, sorry, we could go to page 1664, paragraph 44, from paragraph 44, where, I beg your pardon again, if we go a little back, 1664, paragraph 42. We say that because this meeting was convened during the COVID pandemic period, a register of those attending was taken as required by the COVID protocols and regulation. The list appearing as annexure KM8 was prepared for that reason, but is now used as a meeting of the Zulu royal family. It appears that when Prince Buthelezi heard about this gathering, he opportunistically decided to call a meeting of those present to attend the meeting. There was no notice or agenda for this meeting. It is clear from the list, and we will know that there was no notice except someone who claimed to have called members that should have attended the meeting. There was no agenda for this meeting. It is clear from the list in KM8 that many of those are not members of the royal family and therefore not entitled to be present at the meeting to identify a successor to the throne. In any event, Prince Buthelezi neither consulted nor had no authority from the royal family to call such an important meeting under those circumstances of a ritual cleansing ceremony. So the second respondent has attached a list of attendees to the meeting. And I want to go straight to where there are serious problems when one looks at that, the list that was provided. And that is in paragraph 48. The first is that the type list 1, Annexure KM9, demonstrate that some attendees were not members of the royal family. For example, number 8 in the list is Princess Phumzile. It's recorded as coming from the royal house of KwaKhangela and the lineage of Kings Welithini Zulu. There is no member of the royal family by the name of Princess Phumzile from KwaKhangela. The Phumzile we know is of Prince Buthelezi's daughter from KwaPindangeni. Number 9 is recorded as Prince Ntozis from a house or institution called Wapindange and the lineage of King Solomon. There is no royal house called Wapindange, as it is Prince Buthelez's home. Prince Ntozis does not come from the lineage of King Solomon. Number 17 of the type list has no name. Number 18 is Pilane Maposa, who is not a member of the royal family. Number 19 is St. Zulu, who is from the institution called Ntem, and you'll see there it's not even complete. There is no such royal family. Number 22 is recorded as Ekaba, who is allegedly in Induna Yagwa Kangela. This is false. Induna Yagwa Kangela is Ndwandwe and not Kaba. Second respondent ought to know rather than this information. Number 23 is not named, yet is recorded as coming from the house of Wakangela and the lineage of the second respondent's father. Number 24 is recorded as Lamini from the house of Pongola. There is no such a house, a royal house in the Zulu royal family. There is similarly no lineage recorded. Number 30 is referred as Indunkulu, and no further details are recorded. Number 31 is someone whose name is not recorded, but whose house is recorded as the Usutu royal house and lineage as that of King Zolitini Beuzu. Number 32 is recorded as Indunkulu Dlamini from the institution or house called Edumbe. Since there is no Zulu royal house called Edumbe, it must be an institution. There are no further details of this institution and its relationship to the royal family. Number 40 is recorded as Esentembu from an institution called Enyonini. Because there is no royal house called Enyonini, Mr. Ntembo's lineage is not recorded. Number 41 is recorded as Tulebona Zulu from an institution called Ebu Sisweni Endumeni Kamfihlo. There is no royal house by this name. In any event, his lineage is not indicated. So you will read all this that is recorded in these paragraphs, and you will see that reliance on this minute of the 14th of May as evidence of a meeting of the royal family, it cannot be right. It's not a meeting of the royal family, yes, but it's not a meeting of the royal family that is a duty to identify. And then the further problem, obviously, with the allegation that the meeting of the 14th of May 2021 was a meeting of the royal family, is that there's all the people that attended that meeting were members of the royal family who, with the right to identify an heir, do not file any confirmatory affidavits. You would have expected members of the royal family who were present on the meeting of the 14th of May to file a confirmatory affidavit confirming that they were attending there for the purpose of identification of an heir. But we've indicated a significant number of people who are recorded in the minute and in the attendance register who were not members of the royal family. And with respect, that meeting cannot have been a meeting of the royal family. That is a duty to identify an heir. And it's not disputed that there were no consultations made with the brothers of the late king by Prince Buthelezi when that meeting was scheduled. No consultations. He doesn't say so himself. And there's a much more bigger problem. And I glad that my learned friend appears to have not relied entirely on the document that purports to be an affidavit from Prince Buthelezi. In the review application, Prince Buthelezi did not file an answering affidavit. And yet, the meeting of the 14th of May hangs entirely on him. And we know why he did not file an affidavit. You will find that in the affidavit of of King Zulu, which is in volume 21, page 4141. That's where it begins.
Sorry, volume?
Volume 21, page 4141. That's where the affidavit begins. And in this affidavit, you'll see from page
I see, Mr. Masood, that it's 4 o'clock now, but we're not rushing you to finish.
No,
If you still have some more submissions to make, that's fine.
Yes.
We can proceed tomorrow.
I do,
Yes.
and I crave a moment to reflect on some of the things that you've been putting to me. So tomorrow I'll be a bit sharper than I have been.
Second part is here. All right, but we still have about 5 minutes, Mr. Masood.
Yes. So, my lord, if you look at that affidavit,
Yes.
I want to point a specific paragraph where he explains why the affidavit was not filed on time.
Yes.
Sorry, my lord, I'm just trying to cruise through to see exactly which paragraphs I must. No, sorry. Is the affidavit, the postponement affidavit? Sorry, so it's volume 19, but hang on to that paragraph, that volume, because it's an important volume, what I'm going to say. So if you look at volume 19, page 3723. He says from paragraph 3.1, page 3727, after being served with 2 applications under the 2 case numbers and on the advice of Prince Mangosuthu Buthelezi in his capacity as traditional Prime Minister of the Zulu nation, we instructed and mandated Strauss Daly to act as our attorneys of record in both matters. And then he explains that they accepted the instructions. And then he says, paragraph 3.3, given Prince Buthelezi's capacity as traditional prime minister and head of the Zulu royal family. And may I just pause there? Prince Buthelezi was not the head of the Zulu royal family. He was not the head of the Zulu royal family. The late king was the head of the Zulu royal family. So that's an error there. And then he explains that Prince Buthelezi was to depose a comprehensive affidavit, and then when that happened, he expected that affidavit to be deposed. You see, paragraph 3.4. He says, on this basis, Strauss Daly, in their capacity as the attorneys of record for both Prince Buthelezi and myself, briefed Advocate Madonsela to attend with the drafting and settlement of affidavits. And then he says that all relevant acted in good faith but mistaken belief that Strauss Daly would attend to these matters on our behalf, and further that they would communicate. But that whole section that deals with silent facts and good cause for postponement is important for the court to have regards to. The issue I would point out is that at some point the king says Buthelezi essentially refused to sign the affidavit. And he says, I'm not going to give you reasons why he refused. Although they met and he knows what the reasons are. He says, I'm not going to give you those reasons. And that's why you can't rely on the affidavit. You can't rely on it. Because if Prince Buthelezi, who had the affidavit in his hand, said, I am not signing this affidavit, that says a lot. And precisely because his authority to represent the Zulu royal family had specifically been asked by Prince Mbonisi. And that was it was specifically asked to state on what authority he is representing the royal family and who in the royal family is represented. Now those are critical questions because they answer the question of his authority to even call the meetings that the review application was asking him to explain. At the very least, because he was the author of the meeting of the 14th of May 2021, the review application was the best place to place whatever evidence he needed to place in order to justify the meeting of the 14th as a meeting of the royal family. So in the review application, there was no affidavit by Prince Buthelezi. And I can understand that the reliance is now placed in affidavits that were filed in other court applications where the interdicts were being sought and where that aspect of the meeting of the 14th was dealt with. But if you are looking at the review application of the Prince Mbonisi, and you're asking yourself who in the respondents must deal with the meeting of the 14th of May 2021, it is Prince Buthelezi. And here, the king tells us Prince Buthelezi refused to sign an affidavit that had been drafted and that was ready for signature. But he won't tell us why he did not sign. So you can't even use it because the reason why he did not want to sign the affidavit must say to the court in the review application, as far as Prince Buthelezi's obligation to explain the problems that were raised by Prince Mbonisi, he didn't answer that question. He didn't answer anything about the meeting of the 14th. And now we have to go into applications that did not specifically challenge and seek to review and set aside the meeting of the 14th. And you will know that all the interdictory affidavits that are referred to, especially the ones that where it suggested that the res judicata principle applies, they were all applications in which there was no attack, lawfulness attack on the meeting of the 14th of May 2021. All that the royal family said was we need time. So Prince Mbonisi's approach was interdict any process that will make it difficult for the royal family to perform their ancient responsibility, which is to identify an heir. It was an interdict. It was not a review. So there was no attempt to look at the record with a view to determining whether or not the meeting of the 14th of May 2021 was a meeting that met the requirements of a Section 8.1a meeting, the Section 8.1 meeting of the royal family.
But the issues in both proceedings, was it not the same issue whether or not King Zulu's identification was in accordance with customary law and custom?
No, it wasn't. Especially if you look at the identified specific relief that Prince Mbonisi is saying. But can I just pick something? I want to answer the question quickly.
Yeah.
But if you go to volume 21, page 4063, the notice in terms of Rule 7 is the one that deals with the authority of Prince Buthelezi to represent the royal family. That's volume 21, page 4063.
Yes.
So in volume 1, you will see that what is very volume 1, which is the judgment of Madondo, it's on page the page is at page 126, but the specific paragraph that I wish to refer to is, Deputy President, you did mention paragraph 91. Paragraph 91. Essentially, Justice Matondo was not creating a res judicata scenario in respect of his findings. He was aware, as
Okay, we have introduced now the new subject, so the time is against you.
I'm happy to stop
Unless,
here,
of
but
course,
I just wanted to say
Yes.
the right of any member of the royal family was reserved in the judgment of Matondo to challenge any of the findings that were not in an appeal. He specifically refers in paragraph 91 to a review, and I was going to refer to volume 21, page 4156, which is an affidavit of His Majesty King in Zulu, Kazwelithini Zulu, paragraph 5.8, which specifically sets out the legal position in respect of the review. It says, pending the decision to recognize and identify the king, the president or the premier is obligated by the Leadership Act to ensure that the identification process complied with customary laws, customs and processes. In other words, the internal processes prescribed by the Leadership Act must be followed before a decision could become subject of a review. So, Justice Matondo himself did not create a situation of res judicata because he accepted entirely that the issue of the lawfulness of the meetings of the 14th of May were issues that could be litigated in a review application. He was in no position to deal with the amount of material that the review application has had to deal with, which includes the record from the president telling us exactly what in the president's desk, what was there in the president's desk that he considered before making a decision to recognize at that time Prince Mzuzu.
All right, with that, the court will adjourn until tomorrow, same time, for us to turn. Mr. Masu, you are still on your feet. All right, the court adjourns until tomorrow. Thank you.